Lord, I have filed for interim bail, ma'am. Why?
Lordship, may I be pardoned to make a mention, Your Lordship? I have challenged the advertisement. Advertisement was issued. If
Little louder.
will be. Advertisement was there, which an office order was issued through the advertisement, and that which is contrary to the advertisement, Your Lordship, to which I challenged before the tribunal, central tribunal. Your Lordship,
What kind?
service matter, Your Lordship, regarding the recruitment, Your Lordship.
Okay.
Promotion comes seniority basis, Your Lordship. And that I've challenged before the tribunal, which the tribunal did not allow my application. Meanwhile, Your Lordship, BIBA has been completed yesterday. So they may publish the final list, Your Lordship. I pray before Your Lordship, let it be list.
Final order of the
Not the final order, Your Lordship.
interim order.
The order, office order of the advertisement, which is contrary to the advertisement.
No.
That I have challenged, Your Lordship.
What order has been filed?
They
there?
dismiss my application, Your
Also,
Lordship.
against that you have.
Against that I have come. My Lord, I pray tomorrow, Your
No,
Lordship.
tomorrow this bench is not there. Please give it.
Monday, Your Lordship.
Yes, please give it.
My lord, appellant is corporate to more than 11 years. I filed IA.
Give it.
My lordship, trace arguments. To mention, it's a fresh admission for petitioner challenging the recovery officer's order. For
Give it.
The 2022 appeal, ma'am, specifically at the notice.
Bail.
Bail.
Criminal appeal for bail, my lord.
And to make few mentions, Your Lordship, sir, the matter was listed since last 10 weeks before this bench. Your Lordship, the matter has now been delisted.
Is it for final disposal?
For orders, Your Lordship, bail.
Orders.
Your Lordship, for extension of time for surrender, Your Lordship.
Extension
And
of time.
another application for extension of time to surrender, Your Lordship, interim bail.
Give it.
And 3 appeal matters, Your Lordship. The appellants have been in custody since last 4
Give
years.
it.
Lordship, the petition is in custody since last 17
Please
years.
give it.
The Lordship, I'm mentioning IA number 490 of 2025 filed for interim bail on medical grounds.
Please give it.
I don't to mention, madam. Madam, I item 50 pro. Person difficulty on the also
It's an orders matter. Why are you mentioning? When the matter reaches, you make a mention. Yes.
obviously.
Supplementary list, item number 1.
Lordship on the previous official granted us time to file the supplementary affidavit. Because the affidavit is ready. The only predicament is the concerning officer who has to sign this as my lord is under some medical emergency, has met with an accident. So I pray your lordship may grant time after vacations will file the meanwhile.
When the matter was taken off on 25/8/2025, the learned counsel for the petitioner took time to file supplementary affidavit relating to the subsequent development. The learned counsel submits that the more time is required for such purpose and the matter may be taken up after understanding this matter. Yes.
Item 2.
In terms of order dated 25th August, the affidavit has been filed. That the opportunity was not given that same day it was disposed of. No counter was given, time was given to file counter. As well as the delay in filing of the.
This original application order, influent order, which you are challenging is
On page 22. Except to page 22.
Prior to this, similar other petitions, the SLP is
No,
pending.
this
still.
order which you are challenging, it was passed on 11/12/2018. And you are challenging the order in 2025,
Right.
2024.
24.
2024. So,
The two, basically the two grounds has been
and
taken.
in the first line, it is mentioned that hired Mr. P.K. Mahaparno, learned counsel for the applicant, and Mr. Learned standing counsel. So hearing both of you, both
Here
the
is the-
side, the order was passed, and that too on 11/12/2018.
Madam.
And the OA was allowed. And thereafter, perhaps the contempt petitions were also filed. And now one of, as you said, one contempt petition is now also pending.
Miss
That
SLP
is the
is
reason why you are
arising
challenging the
out of
order.
same. Self-same dispute I have offered in my petitions, SLP pending. That was the 9/9, it was listed.
Do not know.
Even here is the case, the affidavit I have filed. The affidavit, the Lordship may kind of glance, the order includes the affidavit. Page 9. The tribunal practice means a copy of the state council who are normally the standing council there. The first was registered on 10/11/2018. The next date is order of disposal. Is their practice in view of the previous order passed in the similar situated cases, this order was passed.
How
But there is
many,
no-
how many contempt petitions have already been filed for implementation of this order?
But I have to verify. The SLP is pending, still it is
We do
subject.
not know whether SLP is pending or not.
Contempt I have to
That's it.
verify.
You are trying to explain the delay by this affidavit,
Yes, sir.
which was not before the tribunal. You can't add the grounds, sufficient ground you have to show the sufficient ground to the court for the first instance. You
That-
can't keep on improving your sufficient ground.
Sufficient ground is the author, 18 order was passed. Therefore, the matter was pending for consideration. By that time, the matter was pending for the government.
Particular facts of the present case. It will not be treated as a precedent, obviously.
Our contention, the present petition is not entitled for MSCB because the original service period was wrong, erroneously counted that is the service period.
Delay and laches is a ground to reject the.
Yes, my submission that SLP is pending similar situated cases that I have done, this is the order.
Will be pending regarding
This
RSCP.
issue, yes.
RSCP, but this is an exclusive case. Give benefit to this one man. How does it make difference?
And he is not entitled
For
for
the
that.
state land
He is not entitled. You lot see me.
The-
You lot for moment. You lot-
Enforcement
How
of
how the order
is
is,
one, so the land counsel for the petitioner has filed the affidavit of assistant conservator of forest land.
the erroneous assumption the order has passed. That's because he was a forester. Normally, he was not forester. He was appointed in some, as a forest level workers.
For explaining the delay in challenging the informed order dated such and such in the year 2024. Accordingly, the writ petition, otherwise there is no infirmity in the order. The writ
No,
petition.
interim matter, may I submit
Next.
matter? The entitlement is.
Yes, next, yes,
The second is similar.
yes, then dismiss, next.
Item 3,
Here, where is your affidavit, that second matter?
Affidavit is first.
Give it. It a number, that one, it a second matter.
Bar nor a file.
Second is the affidavit. What is it? This order be communicated to the land. It a two order trustee pass person.
State administrative.
No. Since the petitioner has not been noticed in this case, the copy of the order be communicated to the opposite party.
Pending particular facts of the present case.
So that it will have to.
Particular facts of the present case.
Yeah.
Simple spec.
Next.
item 4,
Please, yours. Mr. Conrad, I have filed this review applications for review of order under Annexure 1 dated 4/8/2025. Well, the London Tribunal, following the issue decided in the case of Malayanda Sethi, directed for appointment of the petitioners within a period of 60 days on compassionate ground. My lord. My humble submission is the ground that was taken by the tribunal below was that the 100-point formula came later and the case of the applicant should not have been considered under the new scheme. But-
That point you have raised and we have already decided.
There
Why
is
the
no
question?
finding, my lord, there is no finding to that effect that the court below, instead of directing for consideration of the case of the petitioner under the old scheme, which was prevalent
What
at
is
the
the error on apparent on face?
Lord, my
You can-
humble-
This order may be wrong, you have other remedies.
My lord, there is no finding to
Alright,
that
this
effect that
is-
ground was taken.
This review petition has been filed challenging the order dated so and so. This writ petition was filed on this ground and after hearing the land council for the petitioners Union of India and perusing the impugned order and also considering the ratio laid down in case of so and so South or Kedros. We found that there is no infirmity, legality or perversity in the impugned order dated 2/5/2025. The court those review petition was scoped that the revisions would have to be dismissed. Yes, next.
And there has been a direction to observe him within 60 days, my lord. That is the
Item 5.
The FSC domain supplement for the appellant may lordship. That challenge the order passed by the hearing also.
Third, I am appearing for the State Bank of India. We received the notice. My view is this writ petition is not maintainable. On the ground that they have filed the writ petition under 227, along with the 226. Your Lordship has the power to decide this matter on 226 too, but not under 227.
Don't go technically, whether there is
Why
any
in
clear.
jurisdiction, why not?
So that
DRT order can be challenged in the High Court or not?
that is why recently in one decision, my lord, in Supreme Court,
So wrong provision, mention of wrong provision that don't debar this court to
And
entertain
he
the.
has written 226, 227, forget it, come to the matter.
Come to the merit of it. Yes.
My lordship have already served the copy of the writ petition on 17/2/2024. My signature then filed the objection, my lordship.
it will be admitted then.
Malas, will kindly see the last notice.
This reversing judgment.
My lordship, only on the ground.
Concurring judgment.
Limitation, my lordship,
So concurring judgment, what is the
my
scope?
lordship, only on the ground of limitation, my essay has been dismissed.
DRT order, where is the DRT order?
Okay.
DRT and then DRT. First, we want to see the DRT order.
Yes, 15/11/2023.
What is the annexure?
Annexure 1, my lord, they have cited 15/11/2023.
And the
This is order of the.
DRT order is at 43.
40?
3, page 43.
You come to the page number, internal page 10 and running page 52 of that order. You are the petitioner. Why are you looking here and there? You are not having the brief with you.
Lordship, I have the brief, my lordship, but there's some pages are.
You are not ready.
Yes, ma'am.
you conceal the earlier proceeding also.
Yes, next. It's for an adjournment.
Item 6.
Yes, I am for OP4. OP5, I'm sorry, OP5.
Bank 1 to 4.
And also between me, already copy has also been served up on the auction purchaser also. Keep a copy.
This, Mr. Sahu, Unasa, where is that?
No, my lordship.
He's for Mr. Tunas.
No, sir. These.
So you are for opposite party number 1 and 2,
Yes, my lord.
and you,
No, he's for the petition.
The petitioner, no?
no, in this case, item number, what is it?
Next item.
9-8,
Next
we are in item number 6.
That over.
I'm sorry,
That is over. Item number 6,
My lordship, I am for the petitioner, my lordship. On behalf of Mr. Dalai, my lordship.
what do you want?
My lordship, on the last occasion, opposite party number 1 and 2 are likely to file an affidavit, my lordship.
That is why we
My
want.
lordship, a short time is required, so 5 minutes, 7 days time will not be allowed.
And counsel for the opposite party number 1 and 2 seek some more time to file the affidavit. As per the order dated 9/7/2025, put of this matter. Yes.
Okay.
Item 7.
Yes, Lordship. This Lordship, the earlier order, the direction was made to the petitioner to file the consolidated petition, read petition. And accordingly, consolidated petition filed, and it is mentioned by the annex, the flag number 8.
Okay. So,
Consolidated petition, consolidated read petition.
just a minute.
Flag H.
It's
Have you served a copy on the land?
no, they have
count?
not sought copy.
I am not giving copy.
That's day, course of day. Yes, sure, not the copy, in course of day.
Right, as it appears, the land council for the petitioner has filed the consolidated petition, which is on record. However, the land council appearing for opposite party number 2 to 5.
2 to 5 minutes.
Submits that the copy of the consolidated petition has not been sought on him. Let copy of the consolidated petition sought on the land council for the opposite party number 5. Why? Next week for the next week.
Item 8.
Since I'm appearing for the borrower OP number 2, pre-notice appearance. But the state had to take the instructions why the order is not being executed.
What
is
date
on the
was
channel?
supposed to?
Section 14 order was
Section
passed.
Oh, supposed to get instruction.
OP
Who is appearing for state? Got
Item
the,
9.
got the instruction?
Yes, sir. This instruction may not be enough. Just now got the instruction. Has narrated the entire form. Third page, the last page, second paragraph would be relevant to you.
It is Mr. Sumit Kumar Mahanti and his associates filed power for opposite party number 2, Meghamala Dalai, which is taken on record. The name of the land council be reflected in the first list transport. Yes. Paragraph.
Last page, paragraph number 2, that would be relevant.
This instruction,
Yes, sir.
First page, paragraph 2.
Last page,
last page.
last page.
That the date was fixed on 21.
Yes. Sir.
Okay. Date was fixed on 21/4/2025.
Take
Have
for
you
this-
given a copy to the land council? So how you know it?
I'll sir.
Just give him a copy.
This instruction may
It
not
is
be
already
enough.
there,
I'll just-
annexure 8.
This one.
The letter issued by 17 on
No,
17.
no, this is 13/9/2024.
Oh, no, 17/4 letter, there 21st April was mentioned.
That the
No,
date
that
was
is
fixed. Read it out here.
May I read? That the date was fixed on 21/4/2025 to take possession of the scheduled lab, and letter has been issued to the authorized officer, which is enclosed here as annexure sponsor. But due to the engagement of the force in other law and order duty on the said date, it was cancelled. Since then, the authorized officer of the concerned bank has not intimated any development regarding the status of the case filed before the Honorable DRT Cuttack by the borrowers. In the meanwhile, the borrower Meghmala Dorai submitted an application to the authorized officer of the petitioner that she has deposited an amount of 12 lakh in compliance of the order of the Honorable Court. And the case has been filed by her before the DRT in SA number sponsor, which is still pending. This instruction may not be enough.
What was the due amount?
Now the 12 lakhs.
12 lakh he is paid now.
No, not paid.
That's what he-
I have said everything here. The borrower approached this honorable court, Person may
Yeah, but
kindly
the
come to
report
page
indicates,
22, page 22, annexure 3. That is the order passed by this honorable court, dated 15/4/2024. There, this honorable court directed to pay 12 lakhs within 4 weeks, page 23,
So now he is paid.
after 1.5 years.
Then some interest for component you can work it out.
Not 12 lakhs, it was not the 12 lakhs, Lordship may kindly see the order. That time 24 lakhs was due. And this honorable court stated that you pay 12 lakhs within 4 weeks. So he did not pay. So the SARFAESI proceeding proceeded, it went ahead.
So now he has approached the DRT as it appears.
There is
The
no
matter is
stay.
pending.
There is no stay from the DRT.
No. How he deposited this amount? As per the order of the DRT or on his own?
It is order of the and that was deposited now recently after 1.5 years.
So when you will deposit the balance amount, what is the now?
Let my learned senior forward copy of the read petition. I'll file a detailed counter, my lords. Because there are many, because I have to.
We'll send it to mediation.
The order is specific.
My lords.
In the earlier, writ petition, the order was passed that you are to deposit within a specific time limit. That you have not done. Now you are depositing. Now the SARFAESI proceeding has already maybe that third party created.
No, not property has not been auctioned. We have challenged that order before the learned DRT.
SA is pending.
Yes, my lord. 2 SAs are pending.
Why don't you settle it unnecessary?
We have no problem if he pays money.
We'll send it to mediation.
We'll
send it to mediation.
Mediation, your lords.
Go and try. If doesn't happen, then we'll see.
Yes, my lords.
Obliged.
Obliged.
The Learning Council for the state, as per the order dated so and so, produce the written instruction dated 13/9/2024. This is old one. It's not the
39/2025 only. This is a typo.
typographical error.
Yes, sir.
13/9/2025 inadvertently mentioned as 13/9/2024. Wherein it is stated that the opposite party number 2 submitted an application to the authorized officer Authum Investment and Infrastructure Limited, that she had deposited rupees 12 lakhs as per the order of this court.
On 18/5/2025.
As per the order of this court dated, order of this court, and the matter is subjudiced before the learned DRT in SA number 170 of 2025. The written instruction dated so and so 13/9/25 is taken on record. The Learning Council for the petitioner, Mr. Panigrahi, on the other hand, submitted that the writ petition which was filed by the opposite party number 2 before this court in WPC number 7384 of 2024 was disposed of on 15/4/2024, wherein specific order was passed directing the opposite party number 2 to pay sum of rupees 12 lakhs to the finance company within a period of 4 weeks and to file an application for fixation of suitable installment for payment of the rest of the loan due, which is to be considered in proper perspective. But the opposite party number 2 has not made the payment as per the within the period prescribed by this court, nor filed any application for extension of that period, and he has deposited the amount
On
of
12
12 lakh on
19 May 2025.
19 May 2025. So Paragundu, we made a query to the land council for the petitioner as to whether any third party interest has been created in the meantime. The answer was in negative. The land council for the opposite party number 2 submits that a copy of the writ petition we handed over to him, and if the opposite party number 2 is ready and willing to clear all views of the petitioner, let a copy of the writ petition be served on the land council for the opposite party number 2 in view of the nature of dispute between the parties, since it's a question of payment of the outstanding dues by the opposite party number 2 to the petitioner. The matter is referred to the mediation, but it's a formal order and the report to be submitted. Yes, next.
It was the petition served.
Like petition served in court for them, no?
Right.
All right.
Item 9.
Request the state to give me instruction
I'll-
copy.
That copy you just use.
Obliged.
And just correct it 25 for
Right.
it. अच्छा आपण एटा सेटा देई दियौ काहे कि हम लिखिबो आपण करेक्ट करिकि इनिशियल कर दियौ से जो कहलु ने हम सेटा इनएडवर्टेंटली सेटा पूरा से करिकि देई दियौ 25 पर इनिशियल मारि देई दियौ ये
Obliged. When the petitioner hearing is and rice industry in both electrical division matter. It was having only 11 kV because it is a HP consumer 11 kV volt, but due to frequent interruption and low voltage, etc. So he applied under the remunerative scheme for availing 33 kilovolt at the end of it. I have explained everything in para 3 and 4, because of which there is a feasibility report, and in the permission letter also it was assured him that the remunerator under the remunerative scheme, the capital investment which was incurred by the petitioner hearing will be reimbursed after that. And the London GRF also finally gave a perfect verdict, but at the end of the para, it has referred to a judgment of this Honorable Court of 2011, a single bench judgment, my lord. That was actually overruled by a division bench judgment, which is not at this moment by that overruled. But so far as that, even that single bench judgment, if it is interpreted, my lord, that was under a different on a different aspect altogether. My lord, it is a monetary claim. It was after 5 years after that investment, and it was without any scheme and anything. That judgment is a different aspect. It is not applicable to this case, my lord. My lord, if you lordship kindly see at the JRF order, both the JRF order and the ombudsman order was impugned order are in my favor, but ultimately because of the judgment passed by this Honorable Court in 2011, that was not taken. My claim was rejected because that is a monetary claim they have taken, my lord. If you lordship kindly come to page 40, first the interpretation of this page 40, my lord. It is the order passed by the GRF. GRF has no jurisdiction. That's what the single judge has.
40.
40. It starts from 31, but after the entire discussion by petitioner as well as respondent, if you see page 40, last para. It is after interpretation of clause. It is the permission clause, permission under the remunerative scheme. All the clauses taken together. It is opined by the learned GRF that hence it is an admitted fact that the OP has agreed to reimburse the cost of expenditure made by the complainant for the construction of 33 kV line under remunerative scheme norms as per the Appendix 1 of the Code 2019 as per feasibility report as a go-ahead is given to him in response to his application for conversion to 33 kV system. Madam, that once everything is on my favor, please come to page 45, madam, the final operative person. After examining the order, though it is observation is there, but finally the order is after examining the complaint and counter statement submitted by the opposite party and hearing both the parties, the forum concluded that the claim of the complaint regarding constitutional
The GRF, what the GRF has held,
GRF, grievance redressal forum,
what it has held, where is that order?
that page 45.
Page 45.
It starts from page 31, the final,
The operative part.
page 45, my lord.
Please come to that.
Yes. Page 45, the order. After examining the complainant and counter statement submitted by the opposite party, and on hearing both parties, the forum concluded that the claim of the complainant regarding consideration of adjustment total capital cost under remunerative scheme is not maintainable just because being a monetary claim, as this forum has no jurisdiction to entertain the case.
Therefore, read from the top. Observation.
On examination on the claims and counterclaims narrated above, this forum observed that the present case is related to adjustment of capital cost under remunerative scheme. The authorized representative of the complainant requested to the forum to direct the respondent for adjustment of the total amount of capital cost in the monthly bills against the cost of the asset handed over to TPSODL from the monthly bill of April 2024 onwards, along with interest from day one as per remunerative norms and regulation of the OERC distribution condition of supply code 2019. In response to that, the opposite party has stated that as the claim is of civil nature and involving monetary claim, and the said claim is not maintainable under the forum. Further, the opposite party submitted a copy of the judgment passed by the Honorable High Court of Orissa by writ petition number 2225 of 2010 in the matter of executive engineer Tajde Division Capital Dhankanad, Messrs. Rana Sponge Limited, and another regarding extension of benefit under remunerative scheme, where the Honorable High Court has clearly stated that the learned judge has no jurisdiction to entertain the case as per the para 223 of the circular number.
Where is that judgment?
My lord, at page 67.
67.
My lord, it was completely on a different context. My lord, the client here
Read
is...
that part, 2.3.
Yes, my lord. If you lordship come to page 70, para 8, it was lodged, the complaint was lodged before the learned GRF, who has noted to entertain after 5 years. It was not under the scheme. It was not under remunerative scheme. It was... May I read, my lord?
Any contrary decision is there?
Yes, there is a contrary decision, but I am unable to. There is a divisional bench judgment of honorable.
Bring that.
That is.
That is your trump card, and you say that.
No, that I'll bring that. Send someone, and if I kindly give a password.
No question of password. We are fixing it next week.
Even this one.
The council don't come prepared in a halfway manner. Come prepared with the judgment. We say that basing on the single page judgment, the order has been passed by the GRF, which has been confirmed by the ombudsman. If you say that contrary to that, a division bench decision is there, your first duty is to bring it on record.
I'm sorry, one second, madam.
It is an issue of maintainability. Concurrently, two forum has gone against you, relying upon a particular judgment of this High Court. If you say that there is a contrary judgment, you have to come with that judgment.
I'll explain.
We will not go into the factual.
One second, give me
This honorable court has two different.
Let us see.
Where is that?
No.
Other way.
The writ petition has been filed.
One second, please.
No, we cannot stop. This writ petition has been filed by the petitioner, challenging the order dated 15/5/2025 passed by the ombudsman in case number so and so. and thereby upholding the order dated P8 2024 passed in case number 05 of 2024 by the learned GRA Bhanjanagar. It appears that the learned GRA took into account the examining the complaint and counter statement submitted by the opposite party, found that the claim of the complainant is regarding consideration of adjustment of total capital cost under the remunerative scheme. And since it is a monetary claim, the proceeding is not maintainable before the GRA in view of the decision of this court in WPC number Charita Dui 5 of 2010, dated 16 to 2015. And accordingly, the similar view was taken by the learned ombudsman too. The contention of the learned counsel for the petitioner that there are contrary decisions of this court division bench on this issue, and the matter may be taken up next week so that you will replace those decisions. Put up this matter on 22nd of September 2025. Yes.
Item 10.
May I please, Your Lordship? The petitioner properties is a small printing press matter. He had availed a loan from the opposite party bank. 13-2 notice was issued in the on 3/3/2023. After the symbolic possession was taken on 19/7, and after the petitioner submitted an proposal for OTS and deposited 3 lakhs, my lord.
So now you see auction sale notice has been issued.
My lord.
So the forum is available to you, and we cannot entertain this one in view of several decisions of this
My
court,
lord,
as well as the Supreme Court.
third party interest has been created and the auction, the e-auction is.
So everything now you can go to Glepon. The petitioner, the SSC graphics, has filed this petition challenging the
And 6, my lord.
order dated 19/2/2022.
65 pages.
না এরা কো অর্ডারটা চ্যালেঞ্জ করছে না
And 6, my lord.
2024 heard that
Like this also.
acha the
Notice.
the sale notice dated 28/2025 issued under the SARFAESI Act. He further submits that in the meantime third party interest has already been created. He has not included the land council for the petition has not included the successful bidder in this writ petition. Moreover, in view of the decision of the Honorable Supreme Court.
My lord, the order of this honorable court, my lord.
Figure is not there, my lord.
Huh?
Auction ta hai nahi, my lord.
Auction है ही। No, my
Acha. No third party interest has been created. Stop. In view of also decision, since the petitioner has got alternative remedy, the petition is disposed of, giving liberty to the petitioner.
My lord, by the order of this honorable court, my lord, he had deposited the amount, my lord. Still then they have issued the sale of notice, my lord.
Approach up
You
to
have-
there and
Alternative.
now your name is to be reflected.
Yes, my
Tuna
lord. Yes, my lord.
Tuna Soul and Council for the
E-auction is to be held by my lord on 24th, my lord, of this month.
this Allahabad, na? Allahabad Bank.
Yes, my lord.
I filed an IE, my lord.
Now,
What is that?
now Indian Bank, my lord.
Indian Bank, acha, Indian Bank for them. Indian Bank. Are you filing your appearance memo?
I will file.
Otherwise, you will not mention the name. File from the necessary or fetch shadow. Yes, next.
Item 11. In item number 11, the petitioner seeks a direction of the opposite party number bank, your lordship, to refund the amount that was deposited during the purchase of the industrial possession during the public auction, your lordship. Your lordship, the brief facts of the matter is that the ITCO acquires the land, private as well as government land, your lordship, to set up an veneer savan timber project, your lordship. But your lordship, the lands were not recorded. ROR was not recorded in favor of the ITCO, your lordship. Your lordship, NS Utkal Wood Products Private Limited had availed a loan from the opposite party number 3 bank, your lordship, to operate this timber project. And in default of paying the loan, my lord, the industrial possession was put into public auction, and the petitioner purchases the same.
You are the auction purchaser.
Lordship.
You want the money back now
Lordship.
because the land could not be given to you.
Who is to appear for this?
Separate. ITCO and OSFC, they have
Yeah,
separate.
council also the panel na
Separate. They have separate notice. Panel of council there.
This is your limited prayer.
Lordship, because the lordship, annexure 4, your lordship had already approached this honorable court, and it was directed to either to record the petitioner's name or to pay back the money. Now, your lordship.
Earlier you approached this court.
Lordship.
In this case, the petitioner claiming that he deposited 60 lakhs in the way back 97, but
96.
annexure 1, page 100, page 19. Petitioner only deposited 6 lakhs.
No, that can be better. This let them appear and say all these things. His prayer is very specific, and earlier also he has approached this court, and then I think he has filed some representation before the authority. Last representation seems to be on 15/5/25. That is annexure 5. And there also the prayer was made that
The 31 crores.
requested to pay so amount within to my client. Oh, that is a large notice.
Yeah, the refund order was made
Lordship.
and page 57. 57. That was of simple paragraph.
Order is there.
You have complied with all conditions?
Lordship. Yeah.
No. In the
One,
yeah,
that is the order.
No,
That's
so
what his case.
Now what they have stated to your representation?
To approach the opposite party number 3 bank. The ITCO has replied to my representation to approach OSFC bank. But your lordship, both of them are liable to pay me because ITCO is the one who has.
This petition has been filed by Messrs. Products Private Limited with a prayer for a direction to the opposite parties number 2 and 3. That is Orissa Industrial Infrastructure Development Corporation and Orissa State Financial Corporation to refund the amount deposited by the petitioner along with interest thereon at the commercial rate till the date of disbursement within a stipulated time. It appears that the petitioner earlier approached this court in WPC number 481 of 2018. And the said case was disposed of by an order dated 15/3/2023. With following directions. Quote paragraph number 6. Even though the petitioner has complied with the direction given in the letter dated 6/2/1998 issued by A. Who has issued that 6/2/98 letter? Okay, opposite party number 2. Content that petition has not complied is the letter dated 6/2/98. 6/2/1998 is clearly issued by the.
That letter is also not annexed here.
It's not an next one. It was there in the counter affidavit of the opposite party number 2.
No, we just want to know that what is that letter, because your contention is that you have complied with the direction. In spite of that, they are not refunding. So that contention we are mentioning, it must have been issued by the opposite parties. By the opposite parties, for example. But in spite of that, the
Opposite party number 2. That letter was issued by
opposite party number 2.
That is the IDCO.
Opposite party number 2 is
IDCO in that previous writ application.
আচ্ছা, এটার ফার্স্ট পেজটা আছে না?
Yes.
ফার্স্ট টাইটেল না?
Postal 54.
হ্যাঁ, ইটকো আছে, ঠিক আছে, ইটকো है ना এটা. But till then the petitioner has not got refund of the amount together with the interest. And in that connection, a representation was submitted before the opposite parties number 2 and 3 on 15/5/2025, which has been annexed to the writ petition as Annexure 5.
Representation through advocate.
A representation through advocate. Wherein request was made to pay an amount of rupees 31 crores, so and so the amount lekha is page 59, with principal amount of rupees 60 lakhs within a month. On receipt of such representation, the Chief General Manager MSME IDCO issued the letter under Annexure 6 dated 4/7/2025. So, issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Then counsel for the state accepts notice on behalf of opposite party number 1. Copy of the writ petition has already been served on the land counsel for the state. So far as opposite parties number 2 and 3 are concerned, requisites for issuance of notice by speed post, so and so proof of delivery shall be filed within a by next week or so, matter be listed after so and so. Yes.
Item number 12.
The applicant will challenge the judgment 16/1/2025 and sentence order dated 21/1/2025 passed by London Session Judge Khudad Bhubaneswar with in the case of 302 malicious conviction of life, a conviction of
302 case.
34 malicious.
What is the delay?
154 days delay.
160 days. So we are condoning the delay. Number so and so is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 160 days in filing this criminal appeal. Considering the arguments taken in the interim application and hearing the land counsel for both the parties. And since the petitioner has been sentenced to imprisonment for life, we are inclined to condone the delay in filing the criminal appeal. Accordingly, delay is condoned. IA is disposed of, hard admit, call for the trial court report. Land counsel for the appellant shall supply the deposition copies of the witnesses to the land counsel for the state. Interim applications for bail and stay relation of fine shall be considered after receipt of the trial court report. Yes.
Item number 13.
That's 105 days delay in filing the appeal. It's the conviction is under 364A. That is section 34 of the Indian Penal Code.
Life imprisonment with 10,000.
Yes, yes. Appellate application, stay relation filing.
All right. Delay condoned and admit. Start the copy of the.
I have already solved this. I saw them filing the
question received.
No, land counsel for the appellant has already solved the deposition copies of this one. Put up this matter on such and so for consideration of this application for bail and stay relation of time. Yes.
Yes, next week can I take it?
No. Afterward. Yes.
No materials of section 364 is concerned.
Please, okay.
Mechanical conviction also.
Item number 14.
Obligation.
Item 14.
Report next bill that is, the report has not received.
Prisoner's petition of the appellant received at flag praying for early disposal of the case. Letter received from the son of the appellant praying for release of the appellant's funds so state to obtain instruction regarding premature release. Premature release could as well achieve. Or premature release.
These are 9.
Letter केबे करा? अच्छा ये होची ता पुओ लगी जी 2020 रे प्रिजनर्स पिटिशन होची 2021 रे
What is the undergone period?
Premature release.
It's already released. Premature release is
The Land Council for the state has produced the written instruction received from Senior Superintendent Circle Jail Baripada dated 6/5/2025, wherein it is mentioned that the petitioner, appellant has been released prematurely on 30/12/2022 as per the order of the Government of Odisha Law Department, memo number so and so. The letter is taken on record. The jail criminal appeal is disposed of. बाकी से जो उठा हुआ है जो चैलेंज करे वो चाहे तो इंटरव्यू अपील यार उठे कॉपी रखी है ना कॉपी जरूरी रखी है It just comes.
Item 15.
10 years dead in the maintain.
Date. Single appellant.
Single account.
And counsel for the state has produced a written instruction dated 3/5/2025 from the Superintendent Circular Full 1, which indicates that the appellant, Sahoo Hon'Ble, died on 12/2/2023. The written instruction is taken on
22.
23 लगते हैं 12 तो 2023
certificate 22. Full.
अरे देखो तो भाई
हाँ.
करेक्शन करी ना अपन दियंतु हम दियंतु
करेक्शन साइन कर दूंगा
करेक्शन कर साइन कर दियंतु डेथ सर्टिफिकेट अछि
आगे.
अत पर नेक्स्ट करना जी
आगे.
है ना ये अपील टू अपडेट जो 394 अपडेट करिए तो रोड पर है जो if anybody is interested to continue he can file that one at this position अच्छी तरह फॉर्मेटिंग है ना अबेटमेंट ऑफ द एक्टिविटी yes next
Item 16.
ये से लेटर था डेथ सर्टिफिकेट दी रहा है इसमें प्रिंट कर दीजिए next
That's in this case, I have not received the paper.
no whether he is alive or dead or no report
That report.
in incorporation 2011
Madam, press report मांगो.
the Mandakini Pandal and Council has been engaged by the Odisha High Court State Legal Service Fund. So, let a copy of the paper book be supplied to her by the registry. Land Council for the state sometime to obtain instruction regarding the well-being of the appellant. So also his
Correction.
custody certificate. Custody certificate भी नहीं है सुन
Date conduct.
and it appears that she has this is a case of the year 2011.
11.
So 14 years perhaps he has remained in custody. So if he has not been released on bail, if the instruction will be you file an application for bail, okay?
Lordship, one prayer, Lordship. Noting the Monanta Monastery Ponda CH. Noting there.
No, no. हाँ नहीं सेटा बट एपटे ठीक लिखा है ना मंदाकिनी पंडा बोली से एटा आसीबनी एटा भूल लिखा है बट आई थिंक the criminal appeal law you noting थिवो inadvertently नहीं ऑर्डर ठीक लिखा है the जो ऑर्डर रे से माने डीलिंग असिस्टेंट ठीक लिखा है मंदाकिनी पंडा लगा है एटा टाइपोग्राफिकल एरर है এটা তো আসিবনি বলা next it will go after vacation puja holidays so you get the information state council and once he found that he is alive and
I will file the
file interim application for bail. Yes, next.
Item 17.
In this case, although the bail application was rejected, thereafter I have filed another bail application that I have withdrawn because Lordship directed to the matter to be listed for hearing.
You are in custody since when?
Since 2011.
11. You are not released on bail during trial.
No.
Produced in custody, okay. So, final form रो जो custody date देखला बेलକୁ ଆପଣଙ୍କର ପାଖାପାଖି 21 ମାନେ 14 ବର୍ଷ ହେଇଗଲାଣି। What is the case on allegation कौन?
Allegation offense under section 302, 307 IPC. Life imprisonment and
Come to paragraph number 2. Let us see the prosecution case of the judgment. Are you having the copy of the judgment? Please press it.
the prosecution case is that on 29/2011 at about 10 a.m. at village Sapanchua under Khunsa PS, Sambhunath Naik, the injured PW2, had gone to the house of the accused with the barber Pabulu Barik PW3 to cut the hair of the accused. When they entered into the house, the accused shot an arrow to the abdomen of Sambhunath Naik. Holding his belly, he entered into the house of the informant Ranamudhu Naik PW1, shouting the accused not shot an arrow at his belly. It is stated at that time, Raghunath Naik, while coming from the front lane, the accused shot the arrow at his chest despite his request not to assault. The arrow pierced into his chest, seeking Marigali.
All right. When the bail application was rejected earlier?
In 2015, madam.
11
to 2015.
Or the learning council for the petition and learning council for the state. Have you filed any application?
No application.
Are
No application.
Thereafter,
Yes.
thereafter I have filed, but I have withdrawn.
File
No application.
Yes,
File it will be next week. It will be listed.
yes, sir.
This is Padmaja Patnaik, Land Council. You have received the paper book copy.
Yes.
Submit that she has received the copy of the paper book and she intends to file an application for bail. You obtain that custody certificate. Land Council for the state shall obtain the custody certificate. Put up this matter immediately after filing of the interim application. Yes.
Next week, madam. Next week.
Once you file, make a mention. If you file and send the message today itself. Okay. To send the custody certificate.
Item 18.
You file by tomorrow and make a mention so that it can be listed next week. Okay. Yeah.
Item 18. On behalf of Manoj Singh Rao, Madam, I kindly taken out after the vacation.
Are you aware that since when the appellant is in custody?
No, my lord.
11/6/2011. And you have been entrusted to conduct the case. Your client is there in judicial custody for 14 years and you are not even filing a bail application. What is the purpose of entrusting a jail criminal appeal to you?
ତାଙ୍କ ମାଙ୍କ ଦେହ ଖରାପ ହେଇଗଲା ବୋଲି ସେ ଆସିନାହାନ୍ତି ମେଡିକାଲ ନେଇକି ଯାଇଛନ୍ତି ବର୍ତ୍ତମାନ ମତେ ପୋଲିସରେ କହିଲି ତ ମୁଁ
Ask her to file an application for bail. Okay.
File the application, bail application immediately.
You
will not file.
ମୁଁ ଜାଣିନି ମାଇଲର କିଛି ମତେ କହିଲେ ତ ମତେ
She is appointed or somebody else appointed?
No, some Manoj Sunji is making mention on behalf of Miss Manoj Sunji Rao. These cases have been asked and accordingly the registry is now finding out those jail criminal appeal files where there is they have remained in custody for a longer period, but the council have not filed any application for bail. This legal aid briefs, the council are thinking that they are only to argue the final matter when the paperwork is ready and hearing they will argue. That's not the case is given to you and you can file an application for bail also. And here you see that more than 14 years is in custody. but not a single bail application has come forward. What do you say?
Next week पर्यंत मॅडम काम कोण देईल?
Otherwise, you'll change the advocate. What is there?
These are their petitions.
फाइलिंग करके मेंशन करिए मैडम.
We are keeping this matter to Monday. If Mondays you will not file the bail application, we will entrust it to somebody else. Okay?
Yes, ma'am.
Put up this matter on 22nd of September 2025 as the Land Council for the petitioner intends to file an application for bail. Yes.
ବୁଝିପାରିଲେ ତ ଆପଣ ମଣ୍ଡେ ଆପ୍ଲିକେସନ ଫାଇଲ ହେଇଯିବ କୁହନ୍ତୁ ବସ୍.
That you obtain. Custody certificate भी obtain in the meantime.
Item 19.
ताको आपण ये कर दियो जेल तो जान ले है ना मेसेज कर देबे कस्टडी सर्टिफिकेट माने इसे फॉर्मेट रे दिया हवा कथा खाली ये करी इमीडिएटली पढ़ने आसुन.
Item 19.
Yes. No, we have not listed these matters to adjourn for after vacation.
You are for whom?
For the petition, appellant petition.
What's your name?
PK Pandit.
So you have been this High Court legal aid services had entrusted you to argue this matter.
Yes, sir.
And the man is in custody since March 2012. So 13.5 years he has remained in custody. So file an application Monday, file an application for bail.
Otherwise you will bound to change the lawyer.
Yes.
Item 20.
Non-appears कर दिया है ना तो you change कर दिया तो council को से serial list है सी है ना the registration में ये करियो Monday list कर दो.
Item 21.
कागज रीति दी दवा आपके कर दे चलना कौन जफरुल्लाह साहब.
Jafrullah, we are engaging you in this case to file an application for bail.
for Monday.
Okay.
These 13 these matters are pending.
No, the
Here maybe the result, we should assist the
That's
court.
a different story.
Okay.
And take the soft copy and take the
And
soft.
Monday I will argue. I will file an application
the
tomorrow.
man is in custody since
Yes, sir.
2011.
More than 13 years in
13
custody.
years in custody.
Yeah.
I will file an interim application by tomorrow, my lord.
Yes.
All these matters you obtain that certificate.
My lord.
पूरी नहीं engage नहीं पूरी तो आसियो 22 तारीख दिन but like you know the non-appeals body Sheikh Jafrullah is engaged as the counsel for the appellant and he submits that he may be served with a copy of the paperwork. Let a copy of the paperwork be served on the land counsel for the petition and he filed that he will file an application for bail. Put up this matter on 22nd September 2025 with the IA if any filed in the meantime. File कर दूँ तो आज ही ना and custody certificate का सबूत रहेगा. Custody certificate we obtain. Next.
Item 21.
Nobody is there. Trial court report देंगे. ये कहीं और फाइनल for he is not seen.
admit 13-14 ହେଇକି ରହିଯାଇଛି ଆଉ।
Hmm?
13-14 admit ହେଇଯାଇଛି ଆଉ ତାପରେ
Council be asking.
On for you.
In custody, proceeding source.
So, no, but thing is that trial court record is only the ଗୋଟେ part ଆସିଛି ଆଉ ତା ନାହିଁ ଭୁବନେଶ୍ୱର।
Scheduled one, Wednesday.
ହଁ change the counsel ହେଲା। हाँ engage कर दियନ୍ତୁ। You are having a practice of 10 years, I think.
17.
Huh?
17 or 12.
7. Just give the name, so and so.
And for move an application immediately.
Move an application and give your enrollment number.
Yes, sir.
Hey, some urgent sleep.
Immediately move tomorrow, huh? By the time we go.
Custody certificate to be obtained and the intimation shall be given to the land and trial court to send the case diary. And the matter be placed before the register shall send an email to the land and trial court to send the case reports. देखिए क्या होता है final form since though the trial court record has been received though the trial court record has been received but the case diary is not available. The matter be placed before the registered judicial, we shall send an email to the land and trial court to send the case diary immediately so as to this by tomorrow. Put up this matter on Monday for custody certificate. A Bhubaneswar case.
नहीं trial court record
कोड़ा?
ये record रे charge ता नहीं.
Charge नहीं पर किसी नहीं. Charge नहीं final form नहीं किसी नहीं. But it shows that he faced the trial in the court of London first track court number 4 ad hoc additional session judge Bhubaneswar. So maybe in Jharkhanda jail or कारण जिते बड़े jail criminal appeal file कले
special judge Jharkhanda अच्छी
जिते बड़े वकालत नामारे मध्य आसीजी भुवनेश्वर सब जेल भुवनेश्वर लिखा है
special jail prisoner welfare officer special jail
भुवनेश्वर भुवनेश्वर थी वो कि कोड़ी जाई थी वो जल्दी पठी तो अदर जाती गोटे का को बसई दियंते ए सब काम करिया पई इमीडिएटली आसीबो आ सब सब केस पेंडिंग रही छै
हम इंस्ट्रक्शन बेसी समय क्लास चल जाउ हां फाइल पढिबा अपेक्षा ये टेलीफोन कर
ना इगुडा को कि माने कैनॉट यू सी एमानकर के नाहंती
We are also doing same thing, my lord. We are interested, my lord advocate general, we are interested some files we are taking with ourselves in our room, where every day we are calling to the officer in jail by telephone and obtaining instruction.
It's very really
That we have to do.
But see that
people to fund
सेमानकर के नाहंती गरीब लोकड़ा फाइल करछंती लाइफ इम्प्रिजनमेंट
क्या हमारा रिजल्ट अल्टीमेटली
14 वर्ष 15 वर्ष 16 वर्ष धरि रहबे गोटे बेल एप्लिकेशन फाइल होनी किछि होनी we are not able to dispose of those application after merit also
MK's query are appointed and they are sending junior
गोटे जने ऑफिसर को कर किछि जे फाइल बाहर कर पूर्ण सेटा इंस्ट्रक्शन
जण को पूरा बसई दियन जण दि जण बसई दियन तांको एई काम रे लगै न नन हबन अदरवाइज आमे जेंति तांको बाहर करछु वर्तमान जे समस्ते जेतिको जेल क्रिमिनल अपील अछि
that initiative is the better part. जो जेल क्रिमिनल अपील जो लिस्ट ही एडा को जदी लिस्ट ही आगु था
because we made the effort and Tracy is doing
we made
थारे लिस्ट ही
हर लिस्ट
रेगुलराइजेशन
every day come at least 5-6 matters 10 matters
रेडी जेल क्रिमिनल अपील ले पेपर बुक रेडी किंतु सुनानी तो ही परुने
ये तो फाइल करना तो
बेल एप्लिकेशन भी फाइल करना दी माने प्रत्येक वर्षर माने यू सी दिस केसेस 2012 13 onwards these are pending 2009 रो भी पेंडिंग है जी जेल क्रिमिनल फर्स्ट जेल क्रिमिनल अपील 2009 ଆଉ ଏଇ ଯୋଉ ଗୁଡାକ କାହିଁକି କହୁଛି ନା ଏଇ ଜିନିଷ ଗୁଡାକ ଅବଟେନ୍ କରିବା ପାଇଁ ଯୋଉ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ସିଏ ଏଗୁଡାକ ଜଣକୁ ନ ବସେଇଲେ ହବନି। ସେ ଖାଲି କୋଉଠି ପଠେଇବ ଟୁ ଅବଟେନ୍ କରିବ, ତାଙ୍କୁ ଫଲୋ ଅପ୍ କରିବ, କାହିଁ ପଠେଇଲନି, ଡେଟ୍ ଅଛି ଆଣ ପଠାଅ, ହେଲେ
ସେଇଟା ଆମେ କ୍ରାଇମ ବ୍ରାଞ୍ଚକୁ ପୁରା ଲଗେଇଛୁ।
ହଁ
ଆମେ ଆଉ ଏତେ ଫୋନ କରିବା ପାଇଁ କଣ୍ଟାକ୍ଟ ନମ୍ବର ନାହିଁ, କ୍ରାଇମ ବ୍ରାଞ୍ଚକୁ ଲଗେଇ ଦେଇକି ଯୋଉ ଯୋଉଟା ଆସିଲା ଇମିଡିଏଟଲି।
now you see in the meantime ଏଇ ଯୋଉ 2 ମାସ ଭିତରେ କେତେ କ୍ରିମିନାଲ ଅପିଲ ସବୁ ଏକ୍ସପୋଜ ଅଫ୍ ହେଲାଣି
କିଛି
because of this
ପ୍ରିମାଚୁର କିଛି
either death ହେଇଯାଇଛି ନହେଲେ ପ୍ରିମାଚୁର ରିଲିଜ ହେଇଛି। ସୋ ମାନେ ପେଣ୍ଡେନ୍ସି ତ କମୁଛି ନା ଆଟଲିଷ୍ଟ। ସୋ ଆଉ ବେଲ ବି ହଉଛି। ହଁ ସେ ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ତାକୁ ଷ୍ଟ୍ରିମଲାଇନ କରିବାକୁ ହେଲେ ସମସ୍ତଙ୍କର କୋଅର୍ଡିନେଟେଡ ଇଫର୍ଟ ଦରକାର। ୟେସ୍ ନେକ୍ସଟ।
Item 22. 22 my lord. Appellant is in custody for more than about 17 years in custody. I have filed an interim application and your lordship was pleased to grant me interim bail for a period of 3 months by order dated 1/10/2024. Considering my my lord, your lordship kindly glance to my order dated 1/10/2024 in IA number 1
2008 2009-2008 ରୁ କଷ୍ଟଡିରେ ଥିଲେ।
ଆଜ୍ଞା ସେଥିରେ ଅର୍ଡରଟାରେ ମେନସନ କରି ମୋର ଦେନ୍ 16 ଇୟର୍ସ ବୋଲି ସେଥିରେ 3 ମାସ ଦେଇଥିଲେ। ହି ସରେଣ୍ଡର ଇନ୍ ଟାଇମ୍ ୱିଥ ଗୁଡ କଣ୍ଡକ୍ଟ ସରେଣ୍ଡର କରିଥିଲେ ଟାଇମରେ। ବର୍ତ୍ତମାନ
ସିଙ୍ଗଲ ମର୍ଡର
ଡବଲ ମର୍ଡର ହଁ ବାଇ ୱିଚ କ୍ରାଫ୍ଟିଂ
eyewitnesses there.
Two eyewitnesses that is
One and
mentioned.
two is the eyewitness.
One and two.
Is there any misutilization of
No, my lord,
duty?
certainly not, my lord. He is in custody in time. He surrender.
I already surrendered. Can you file for answer?
ମୋ ପାଖରେ ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ନଥିଲା, ପଛରେ ମୁଁ
No,
ପାଇଲି।
that is there.
ଆଜ୍ଞା।
Premature release होइछि कि नहीं आपनको
ହେଇନି
ଆଉ ତ obviously ହେଇନି। ଦେଖନ୍ତୁ IA number so and so, this is an application for bail. Mr. Jaffrulal and counsel submits that the petitioner, taking into account that the petitioner was in judicial custody for more than 16 years, by order dated 1/10/2024, this court has been pleased to grant interim bail to the petitioner for a period of 3 months. And after availing the same, he surrendered at right time. And he has not misutilized the liberty. And since there is no chance of early hearing of the jail criminal appeal, the bail application may be favorably considered. Land counsel surrender certificate is on record. Considering the submission made by the land counsel for the respective parties, period of detention of the petitioner in judicial custody, the fact that the petitioner has complied the terms and conditions of the interim order dated so and so, you are inclined to release the petitioner on bail allowed.
Let the order be communicated to the
Order be communicated.
because nobody is there to
jail superintendent पठेवे से अच्छी फॉर्मेट रेस्ट जुडिशियल पठेवे ट्रायल कोर्ट को पठेवे प्लस जेल सुपरिटेंडेंट को पठेवे है ना। ये सब से 20,000 वन सिक्योरिटी करेगा गरीब लोग बड़ा बेसिक ये।
Item 23.
16 year 3 month 4 days.
आगे जाइथिला बेल जाइथिला
Not present.
You are the counsel.
No.
Then who is the counsel? You are party.
और जेलो कम्युनिकेट कर दे।
हाँ
ऑर्डर को जेलो कम्युनिकेट कर ले।
No, advocate is to be changed, na, that is the main reason. ये माने जने advocate थिले हमें entrust करू आउ जन को because nobody appeared तापर भी तांकर भी देखना ना
Even present ଅଛନ୍ତି ତାଙ୍କୁ ତ ଦେଇଦେବୁ।
ହଁ ଦେଇଦିଅନ୍ତୁ ଆପଣ ସେ engaged as sworn. Higher number sworn, so there is an application for bail. The land council for the state has written instruction from inspector in charge of Barbil police station to show that there is no other criminal antecedent against the petitioner. He has also produced the custody certificate of the superintendent sub jail Swanshaw, which indicate that the petitioner is in custody 16 years, 3 months, 4 days. The documents produced by the land council for the state taken on record. Considering the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, and the bail is allowed, sent the communicates for them, and is engaged as the Swanshaw, is engaged as the counsel for the Swanshaw. Paper book, paper book copy is supplied.
There are two matters.
Next matter bail lodge.
Huh?
He is on bail.
These are regular.
But 25/10 to 2017.
Already we are engaging in this jail criminal appeal 39. Now the name of this you are party Swanshaw shall not be reflected in the causes. आपन ये नंबर टा दीजिए जो बात हाँ नेक्स्ट
Item 24.
पेपर बुक नहीं जान तो सिग्नेचर करेगी नहीं बाकी बेल लेगला जेते वाला आसीओ सुनानी हो
24.
ये
Item 24.
Bail, previously bail rejected, no bail application filed.
Rejected.
Earlier rejected, and I will also obtain the custody certificate.
स्टे रियलाइजेशन ऑफ फाइन दिला এটা भी अलाउ कर दो ना तो बेल चलते हैं इनके लिए
Bail के थोड़ा बाद अपना custody certificate I will also obtain.
नहीं काउंसिल चेंज होना सेटा हो जी बोलो जी ना नॉन अपीयर्स कर देवे ले राइट नेम ना आनो
Move the application by tomorrow.
engage
file
file an application for bail
Yes, ma'am.
and receive the paper book is to be supplied to him so and so is engaged at the account and land council for the appellant submit that you will file an application for bail by tomorrow. Put up this matter on 22nd September 2025. Land council for the state shall obtain custody certificate. Yes.
Item 25.
अच्छा आदि गोटे अच्छी मिसकेस फॉर स्टे रियलाइजेशन ऑफ फाइन सेटा अलाउ कर दियो ये जो आइटम नंबर 24 है ना
20 I have filed a bail application or rejected on day 2024. Paperwork may kindly supply here.
You file another bail application है ना काली फाइल करो the miscase stay of realization of fine allowed है ना बाकी submit
I will obtain the custody certificate.
अच्छा copy of the paper book be supplied नहीं जान तो paper book and you file bail application by tomorrow कोई देवे submit that you will file the bail application by tomorrow 22/9/2025 register with the interim application. Yes. Fine state कर दो बेटा हाँ next
Custody certificate आसवा 2 दिन पड़ा
custody से अपन चेष्टा करूँ पड़े अच्छे काली वर्किंग डे अच्छी ना किंतु असुविधा
आदि पठे दो छो
हाँ पठी
Item 26.
आपको ये देवे जो मैटर इज पोस्टेड टू स्वानसो सो इट शुड रीच इमीडिएट माने ये रे पठेबे आपन को मस्त की कोन आसीओ दरकार नै
व्हाट्सएप रे पठे
व्हाट्सएप रे पठेबो कोन कर यस नेक्स्ट
Item 26.
Case of remand. It's supposed to get custody certificate.
Yes, yes. से ट्रांसफर ही अन्य जेल को
टोटल पीरियड नहीं आपन पर
टोटल पीरियड का नहीं किंतु जना पड़ी जाउ छै
2012 फाइनल फॉर्म ता देखि हां 26/9/2012 अछि ଆଉ ट्रायल कोर्ट रेकर्ड रे देखौछि जे he was all along in custody.
25/1/2017 जेल केउझर जेल को आसिला 7/10/2023 रे केउझर जेल रु गले ट्रांसफर हेकी करंजिया नाउ इज इन करंजिया.
So obviously it is now केते हबो 13 वर्ष हेगलानी 26/9/2012. So it is likely to be 13 वर्ष likely to be completed very soon. सेटा कोन
Direct evidence.
आउ तो किसी नहीं केस नहीं गोटे केस है जो
गोटे केस
Direct evidence or circumstantial.
The eyewitness contradicted her statement.
eyewitness account is there सेटा कस्टडी रे था ताऊ
earlier your bail application was rejected.
Yes, madam. Twice it was rejected.
Twice.
Yes.
When the last time was rejected on 13/11/2019.
2019. 13/11/2019.
All right, take down the IA number. This is 140 of 2025. This is an application for bail. Learning counsel for the petitioner submits that the petitioner was taken into judicial custody on 26/9/2012, and during trial he was in judicial custody, and his bail application has been earlier rejected twice by this court. First time on 11/8/2016, and second time by the order dated 13/11/2019.
So my witness did not identify. And only so like
ये कौन करेगा पूरा देखो तीन बार देखो ना कौन करेगा
only से जितना भी सुनी पाती हाँ अब कभी सुनेगा.
Considering the submission made by the land counsel for the petitioner that the petitioner has remained in judicial custody for about 13 years, which is 13 years is going to be completed, very soon. We are, and even though the appeal is ready for hearing, but it could not be taken up, we are inclined to release the petitioner on bail. Either this is taken on record, no anticipation.
Okay.
Item 27.
Hello. They got 9 years in the question ourselves.
And then first rape and murder. Not murder, rape subsequently it's a dying, oral dying.
There are custody certificate and yes, on the criminal antecedent. Put up this matter after ensuing puja holidays. In the meantime, the land counsel for the state shall produce the custody certificate, criminal antecedent, if any, against the petitioner, as well as the jail conduct. Yes, next.
Item 28.
May I please the lordship matter? I'm in custody since 18/10/24. I have not received the paper book matter. Maybe taken up Monday. I will do this matter.
24.
Vacation for
Keep
24.
नहीं
2014 आ गया 14
10 वर्ष so let it come on Monday.
Monday, yes, my lord, yes.
Mr. Satyanarayan Mishra 4 land counsel appearing for the appellant 6 for an adjournment to Monday. Release this to 20 next week. Release this matter on 22nd of September 2025. Custody certificate and yes.
Yes.
Yes, oblige, my lord.
Item 29.
please.
77.
Deposition copies and us.
Order. 24 2014 में 24 matter, but custody since 2014. That's right.
Custody since 27/6/2011.
In item number 29, deposition copies are not there.
28,
29.
29.
20.
पेपर बुक ହେଇଯାଇଛି ନାଇଁ ତ
No.
ତ ନେଇଯାଉନାହାନ୍ତି ସଫ୍ଟ କପି ନେଇଯାଆନ୍ତୁ କଲେକ୍ଟ କରିନିଅନ୍ତୁ ଆପଣଙ୍କ ପାଖରେ ଅଛି ଡିପୋଜିସନ କପି
That may be supplied.
ତ ନେକ୍ସଟ ୱିକ୍ ନେଇ ଆସୁଛୁ ଆପଣ ନେଇଯାଆନ୍ତୁ ଆଜି ପେନ୍ ଡ୍ରାଇଭରେ
ଯଦି ଦେଇଦେବି
ଆଚ୍ଛା ଆପଣ ଦେଇଦିଅନ୍ତୁ ଅଛି ଯଦି the land council for the state submit that she is not having the deposition copies with her. Mr. Samantra, land council appearing for the appellant or appellants?
Appellant only.
Appellant. Submit that he will supply the deposition copies during course of the day.
Right.
Put up this matter on Monday. Yes. That is 22nd, 9, 2025. Yes.
Item 40.
Actually, I am number 286.
ତିନିଟା ମ୍ୟାଟର ଅଛି ଆପଣ କୋଉ ମ୍ୟାଟରରେ
286, third matter.
ଥାର୍ଡ ମ୍ୟାଟରରେ ରିପୋର୍ଟ ରିସିଭ୍ ଫ୍ରମ୍ so and so
Very non-offense.
କଣ ଆସିଲା ରିପୋର୍ଟଟା
That key, they have not been apprehended.
No, he is in custody na. Item তিনিটা item ଅଛି item number 30 ରେ he is moving CRLN number 286 up to 2018
The last.
last ଟା ये आसी report आसी is in custody
He is in first. I will placing the report of the first sub-item.
नहीं first में he is mentioning we'll pass the order we'll say that but
Yes, sir.
he is moving this third item
Third one.
third item is in custody so since when you are in judicial custody अच्छा 2014 15/8/2014 ट्रायल कोर्ट रे बेल थिले आपन ना कोन आरो कृष्णा बारिक देखिए ट्रायल कोर्ट ऑर्डर
His bail application was rejected on 28/2/2019. Thereafter, he was released on interim bail twice.
No.
And by this.
Fast pistol.
आज ये बेल जाएंगे दीटा अक्यूज्ड बेल ले थिले बट दिस मैन हैज नॉट या नाउ जी कृष्णा बारी he was throughout in judicial custody तमने वर्तमान तार एला 2014 माने 11 वर्ष कंप्लीट हो गलानी 15/8/2014 अच्छा रिजेक्ट अपन एटा हाई कोर्ट ऑर्डर स्वीटर रिजेक्ट केबे इतला लास्ट टाइम
28/2/2019.
28/2/2019 अच्छा ऑफेंस कोण आदिले 396 कोटिया लोको लोकल कृष्णा बारिक चौहानसो उदो उडो गड़िया चंपुआ जोराशो 3 मिनट तो दे are the learning council for the petition learning council for the state learning council for the petitioner submits that the petitioner was taken into judicial custody on 15/8/2014, and he was never released on bail during trial, and as such, he has remained in custody for more than 11 years. No? Stop. He further submits that the earlier bail application of the petitioner was rejected by order dated 20/2/2019, and even though paperwork has been prepared, but since there is no chance of early hearing, the bail application of the petitioner may be favorably considered. Learned counsel for the state opposed the prayer for bail and submitted that it's a case of conviction of the petitioner under section 396 IPC and 25 and 27 of the Arms Act. Considering the submission made by the learned counsel for the respective parties in view of the nature and gravity of the offense, and while not inclining, and the evidence adduced during trial, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody for more than 11 years. And since there is no chance of early hearing, we are inclined to release as a keeping in view the ratio down in the case of Swansword. Let T 3 months bail. Yes. बाकी एटा देखंतु फास्ट रे नॉन एप्रिहेंशन ऑफ रिपोर्ट आछि काई करा देखिन देखंतु द लर्न एंड ट्रायल कोर्ट नॉन एपियर्स एदरे की एपियर करछन की सीआरएल 329 ऑफ 2016 भारती दास एस सेठी अच्छा लिख दम नॉन एपियर्स पेरू द रिपोर्ट डेटेड on 3/7/2025 submitted by the Learn and Trial Court, which indicates that the appellant, after availing the interim bail period for 3 months, has not surrendered, for which an available warrant of arrest was issued against him, which is yet to be executed. It is further stated that bail in this case has also commenced, and stop. Put up this matter. The Learn and Trial Court, the Learn and Trial Court shall time to time intimate this court about the apprehension of the appellant. After next asun. Yes.
Flag P here.
Flag
P. The report is from the Learned Trial.
Second item tare.
Second item.
363.
363.
No, we are in 363 para second item da.
Okay. 363 Flag P अच्छी report था तो.
Nana कौन आसी? अच्छा सुनका.
Failed to surrender.
Did not surrender. Same thing or?
Then.
Somebody is also from Odisha.
Good. नहीं बात এটা ওরা কেউ ইয়োর প্ল্যান দেখিল আমি পছারি কৃষ্ণবাড়ি চম্পু আবিলা
Local.
এগুলা সব বাহার
बाहर दिला
यूपी रो
इलाहाबाद वाले से इलाहाबाद
हाँ यूपी से फर्स्ट जाइछन्ति তারপরে এটাও বি সেইটাই অর্ডার করদিয়ন্তু যেটা কোটা সেকেন্ড আইটেমটা আচ্ছা আগে কি যে আইএটা ফাইল হইছি extension of the bail application stands rejected. Here is the report of the Learn and Trial Court, which is at flag P, which indicates that the petitioner was Swanson did not surrender, non-available warrant of arrest. He would have called. Bail or miscase has started. See type of like Yes.
Lordship, item 31. Same case, Lordship, petitioner filed the surrender certificate.
you are directed to be released on interim bail.
Lordship.
On what date? By order dated?
Lordship last in 2020.
12/4/2024.
24.
12/4/2024.
Lordship.
No, ତାପରେ ଆଉଥରେ ଯାଇଛନ୍ତି ବୋଧେ?
No lordship.
ହଁ?
No lordship.
1/10/24 ରେ ଅର୍ଡର ହେଇଛି।
1/10/24 ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ଫାଇଲ କରିବା ପାଇଁ ଡାଇରେକ୍ସନ।
ୟା ନା ପ୍ରଦୀପ କୁମାର ଗିରି ତ?
ପ୍ରଦୀପ କୁମାର ଗିରି।
ହଁ, ପ୍ରଦୀପ କୁମାର ଗିରିର 1/10/2024 ରେ ଅର୍ଡର ହଉଛି।
28/11.
ହଁ?
28/11.
ଆମେ ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ଫାଇଲ କରିବା ପାଇଁ ଟାଇମ ନେଇଥିଲୁ।
ଆପଣଙ୍କୁ ନାଇଁ
It was extended. 1/10/2024 it was given and thereafter it was extended
Lordship.
till 24/11/2024.
that is all right. Did you surrender at right time?
Lordship. Surrender sir.
So what was his conduct? Take time. Listen, the land counsel for the appellant has filed the surrender certificate which is taken on record. IA number so and so, this is an application for interim bail. It appears that the petitioner was granted interim bail for a period of 1 month by order dated 1/10/2024, which was extended by order dated 5/11/2024 till 24/11/2024. And the petitioner was asked to surrender before the learning trial. Let the learning counsel for the state obtain instruction regarding the conduct of the petitioner while on interim bail. Eta asu chutti pore.
Lordship, his mother condition is seriously ill and his daughter is 14-year
ଆପଣ
daughter.
ଯାଇଥିଲେ ପରା ଆସିଲା ପୁଣି କଣ?
Lordship 24
He
days.
did not surrender in fact. He sought for extension which was rejected on 25/11.
Surrender କେବେ?
Thereafter NBW was issued.
ଆପଣ surrender
Surrender just 1 day delay Lordship. 25
11
Lordship.
ମାନେ ବେଶୀ ଦିନ ନୁହେଁ. You are supposed to surrender.
Lordship court ରେ file missing.
Wait. ଆପଣଙ୍କୁ ଦିଆ ହେଇଥିଲା ସ୍ପେସିଫିକ ଅର୍ଡର ପାସ୍ ହେଇଥିଲା 25/11/2024 ରେ ସରେଣ୍ଡର କରିବାକୁ। ଆପଣ ସରେଣ୍ଡର କଲେ 28/11/2000, 3 ଦିନ ପରେ।
Lordship. କୋର୍ଟ ରେ ଫାଇଲ ମିସପ୍ଲେସ୍ ଥିଲା, ସେଇଥିପାଇଁ ସେ ସରେଣ୍ଡର ଯାଇଥିଲା, ତାକୁ ରିଟର୍ନ କରିଦେଇଥିଲେ।
ଠିକ ଅଛି, ଆପଣ ଯାଇଥିଲେ ଆଉ କଣ ବର୍ତ୍ତମାନ କୋଉ ଗ୍ରାଉଣ୍ଡରେ ଫାଇଲ କରୁଛନ୍ତି?
Lordship, his mother condition is seriously ill and his 14-year daughter is missing. Lordship, daughter recovery.
ଦିଅନ୍ତୁ। ଆଚ୍ଛା, ଆସୁ ତାହେଲେ 24 ତାରିଖ ଆସୁ 24th। ଆଉ ଏଇ ଯୋଉ medical documents, interim bail on the ground of medical on the health condition of the mother who is supposed to be who is stated to be suffering from cancer, and also the ailment of the daughter, and the medical documents have been annexed to the interim application. Land counsel for the state shall so and so set of obtain for the conduct as well as the authenticity of the medical documents annexed to the interim application matter to be listed on 24th September 2020.
Lots.
Yes.
24 September.
हाँ, 24 तारीख को 24/9/2025।
Item 32.
Pleasure, Lordship. उसका fourth application for bail before your Lordship, my lord. Earlier, the petitioner was initially custody since 2010-2014, my lord. Offense under section 3.
ଆପଣ ବେଲ୍ ଯାଇଥିଲେ interim bail?
Yes, my lord.
କେବେ କେବେ?
That is dated, my lord, 29/7/2024 for a period of 3 months.
अच्छा, तापरे
IA number 2897/2024, that is dispose of on merit, my lord, 25/11/2024. Thereafter, one IA is filed on the illness ground of his mother And the report was called for that mother was in the meantime discharged from the hospital. Thereafter, I was disposed of on 5/4/2025. And in the meantime, I have obtained the custody
ଆପଣ ଦିଥର ଯାଇଛନ୍ତି total bail, interim bail.
CORAM.
But it is mentioned, it appears that the petitioner approached this court for bail twice. अच्छा, ଏଥିରେ ଗୋଟେ dispose of ହେଇଛି 29/7/2024 ରେ ଆପଣଙ୍କୁ bail ଦିଆ ହେଇଛି
Yes, my lord.
for a period of
3 months.
3 months. ଆଉ ଗୋଟେ ହଉଛି ଆପଣଙ୍କର
20th January 2000.
28/27/2024, which was disposed of on merit.
अच्छा,
On 25/11/2024. Thereafter, petitioner filed the interim bail on the illness ground of his mother. He was admitted in hospital for a brain stroke patient. Thereafter, in the meantime, report was called for. She was discharged from the hospital. And his bail application, I was disposed on 5/4/2025.
ସେଇ ground ରେ ତେଣୁ ଆମେ ଦେଲୁନି ଯୋଉ ଆପଣ mother
ଆଜ୍ଞା, ତା discharge ହେଇଥିଲେ ଦିଆହେଲା।
ତାପରେ ବର୍ତ୍ତମାନ କଣ ପାଇଁ ଫାଇଲ କରିଛନ୍ତି?
Now I have obtained the custody certificate, my lord. The petitioner is custody since 2010-2024. In the meantime, 3 of the co-accused person have been released on bail.
ଏଇ କେସ୍ ର
Yes, my lord.
ଏଇ କେସ୍ ର ତ 7 ଜଣ ଟ୍ରାଏଲ ଫେସ୍ କରୁଥିଲେ।
Yes.
କେତେ ଜଣ କନଭିକ୍ସନ ହେଲା?
Conviction ହେଲା 5 person, my lord.
And out of them, 3 have been released on bail.
Yes, my lord.
पूरा bail ना और फिर interim?
Pura bail, my lord. This is the copy, my lord.
Just a minute.
This is a matter under POCSO. We have, the notice was served to the victim informant. He has stated.
এটা তো bail order নୁହେଁ।
My lord, one appeal pending.
Item 33.
Your Lordship, on behalf of Mr. Gopalan on the Sahoo, I will be permitted to place this matter. I have filed IA for bail. Bail since 8/11/12, 12 years, 10 months. And conviction under section 302 and 34, sentence of life imprisonment and fine of 1,000.
Appellant two.
9/11/2012.
Yes, Your Lordship.
So, you are not on bail during trial?
No, Your Lordship.
He was not released on bail. So far as this court is concerned, how many times your bail application was earlier rejected?
While granting bail to appellant number 2, your bail application was rejected.
Appellant number 2, Prabhati Pradhan. Prabhati is released on bail. By the way, what is the case against you?
Your Lordship, allegation is that the dispute is between two brothers, Your Lordship, and the appellant dealt a axe blow to the deceased person and
Axe blow, yes.
axe blow, Your Lordship.
Which part of the body?
Head, Your Lordship.
Eyewitnesses are there.
Wife
Yes,
of
Your
the
Lordship.
deceased.
PW5.
But it shows that about you will be after 2 months, it will be 13 years you will complete. A bail agu reject bhi nahi.
No, reject.
Is a local man or outsider?
Hello.
Local. Local. Are the learning council for the petitioner and counsel for the state. And counsel for the petitioner submits that the petitioner was taken into judicial custody on 9/11/2012.
8/11/12.
8/11, judicial custody is 9/11 because you are produced in court on 9/11, arrested by police on 8/11. So, and he was never released on bail during the trial. The co-accused has been directed to be released on bail by this court by the order dated 19/11/2018. He further submitted that the prosecution case is that the petitioner assaulted the deceased. What is the relationship between the petitioner?
Brother.
Who was his brother by means of an axe, as a result of which he died. And since there is no chance of the hearing of the appeal in the near future, the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail mainly on the ground that PW1 eyewitness came. PW5, the widow of the deceased.
Yes, sir.
The widow of the deceased is an eyewitness to the other. And her version is getting corroboration from the evidence of the doctor 17 who conducted PW17 who conducted postmortem examination.
Leading to discovery. Confessional actually. Confession भी अच्छा. Confessional statement.
Apart from other evidence on record. So considering the submission made by the land council for the respective parties, the nature of evidence available on record, the period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail. Yes.
Informant को threaten करेंगे.
The petitioner shall not indulge in any criminal activities while on bail and shall not come in contact with the family members of the deceased in any manner. Violation of any terms and conditions shall entail cancellation. Yes, this is filed for apparent number 1. Yeah.
Give your appeals, writing.
Item 34.
The surrender certificate.
Was,
5/12/24 रे interim bill दे.
Yes, what is your instruction?
On that instruction is not appeal the interim bill.
What is your good name?
Rakesh Kumar Das.
Rakesh Kumar Das. You are making submission on behalf of Mr. Ramanikant Patnaik. Mr. Rakesh Kumar Das, Land Council, Mr. R.K. Patnaik submits that though the matter has been listed for non-filing of the surrender certificate of the appellant, but even though this court has directed the appellant to be released on bail, interim bail for a period of 3 months, by order dated 5/12/2024 in IA number 2104 of 2024, but he has instruction that the appellant has not availed the interim bail period. Let a report be called for from the London Trial Court as to whether the appellant Raja alias Swansu has availed the interim bail period or not. Put of this matter on such and such date after order be communicated by the registered judicial in the year.
Item number 35.
Yes, Ms. Tripathi.
My lord, therefore, bail, I number 940/2025. Convention upon live imprisonment offence committed under section 394, 302, 201 and 102B in Indian Penal Code. Date of occurrence 8/3/2010.
No, you have filed application for bail for whom?
In 3 months.
No. कहाँ पाई बर्तमान फाइल कर चंदी?
Two accused persons.
2 जन पाई.
Amit Baria and Tarin.
Earlier you filed an application for bail.
My lord.
And you are granted interim bail for a
3
period of 3 months.
3 months.
So what happened then? Have you surrendered in time?
My lord. 4/12/2024 ରେ order ରହିଥିଲା କିନ୍ତୁ ସେମାନେ ରିଲିଜ ହେଲେ 4/12/2024 ରେ ଯୋଉ 13/3/2025 ରେ ସରେଣ୍ଡର କଲେ ରାଇଟ ଟାଇମ ରେ ସରେଣ୍ଡର କଲେ ପିରିୟड ଅଫ କଷ୍ଟଡି 14 years 6 months.
14 years, 8 months. तो ଜଣଙ୍କର ଆଣିଛନ୍ତି
ଦି ଜଣଙ୍କର
same time.
Name of the convict ରେ ଦିଟା
Are the learned counsel for the petitioner is Minapani Tripathi and Mr. Mahanti, learned counsel for the state. The learned counsel for the appellants produced the custody certificate of both the appellants, which indicate that they are in judicial custody for 14 years, 8 months. The custody certificates are taken on record. She further submits that the petitioner was directed to be released on interim bail as per order dated 4/12/2024. And after interim bail for 3 months later. And after availing the interim bail period, they surrender at right time. And they have not misutilized their liberty in any manner. And since there is no chance of early hearing of the criminal appeal to near futures, even though paper book has been prepared, the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail considering the submission, period of detention of the petitioner in judicial custody, fact that the petitioner, there is no allegation against the petitioners to have misutilized their liberty in any manner while on interim bail, and absence of any chance of early hearing. We are inclined to release the petitioners on bail allowed. Item
number 36.
36 minutes, a petitioner appellant filed an IA number 1468 of 2020-25 for interim bail for 3 months. On grounds that the appellant suffering from severe eye disease and both the eyes seriously affected, and he is unable to see, and the right side tear continuously flowing.
But it appears that you have misutilized the liberty.
No,
While on interim bail,
yes,
one case was instituted against you at Uddala police station.
This,
And,
this is not.
and charge sheet has also been submitted.
No, this is not our knowledge, Miller.
No, this is the
controlled
order.
by informant, Miller.
No, sir, threaten the informant. Interim threaten the informant.
So question is that we are also, while granting interim bail,
Yes, yes.
we are imposing the condition that they should not indulge in any criminal activities. So now, while on bail also you have indulged yourself. FIR lodged and charge sheet has also been submitted. So that shows that prima facie you have misutilized the liberty. How you will be granted bail?
No, Miller, this is a plantation by informant's relation. I have no knowledge about this.
May be correct, but fact remains that it's not only an FIR, but it was investigated upon and it was found that the allegations are true.
Court has taken cognizance.
Court must have taken cognizance also on the charge sheet.
No, Miller,
So how can we grant bail?
I am in custody in this case, Miller.
No, not in this case. In this case, you are convicted and sentenced for life imprisonment. You are granted bail by this court for a period of 3 months.
Yes, Miller.
But while on interim bail, you have again indulged in this type of activities.
No, Miller, petitioner has not violated terms and conditions.
Are you disputing that the case has been instituted against you and charge sheet has been? Have you seen the order dated 23/5/2025? What is how you have explained it? This is the statement of the State Council, and he has produced the written instruction from IIC Uddala Police Station.
Madam, do you know?
Humanitarian-
Have you realized? See, what happens is if you are in the long custody, if the appeal is not heard, generally we give 3 months bail to watch you what is your conduct outside the jail.
Yes, my lord.
And if you indulge in criminal cases further, no regular bail can be granted.
That's the
We have given 3 months interim bail, and you have indulged in one of the criminal case.
2 to 3.
Charge sheet is filed, cognizance is taken in that case.
My lord, 2 to 3 times he was done in bail, already in interim bail. The certificate conduct of the petitioner is good.
No, that's the problem.
That is the,
Oh,
that is the,
put up this matter after vacation. Next.
Item 37.
May. Convicted and sentenced.
Here. Padma Birua, the lady in custody since 18/1/2015, or you are granted bail during
No.
trial.
No.
The custody certificate and other aspect will be.
In the meantime, 10 years, 8 months.
What are you giving us?
Death certificate.
No. Have you got the custody certificate?
No.
Custody certificate and.
From the date of arrest till
No.
10 years, 8 months.
During that period of corona, many persons were granted, so that is obviously, that cannot be considered. So one
No,
custody certificate.
Let it come.
No, let it come, let him obtain it. It will come next week. We are not put up this matter next week. Because this lady, we are putting it next week. The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody on 18/1/2015, and he was never released on bail or on parole. Stop. Learned counsel for the state shall obtain instruction in this matter and produce the custody certificate. Put up this matter on 24th of this September 2024. Yes.
Item 38.
The appellant petitioner was in custody over 9 years. This is the case wherein in this case he has remained for 9 years, but while he was in custody, then when a jailbreak activity, all the inmates of the jails they escaped, including the petitioners. He was
82,
arrested,
83
he faced trial and was acquitted. Lordship may see order dated.
So you
28.
escaped from jail in 2006 and you are arrested in 2017. 11 वर्ष absconder.
No, 7. Lordship may see order dated 48.
Yes, we have seen that.
28. 48 sir. 48 है अपन order सा kind.
Yes.
In second paragraph, we have written that.
Yes, I have written. And he was acquitted. It's not that, but the order wherein the bail was refused by the honorable court. It is mentioned that he escaped from the jail and after 10 years, but he was inside the other case. That is what I have got the certified copy where he was acquitted in that case. In that case, he was inside there. But besides the period, he was.
How many criminal antecedents are there? The Naxalite activities.
That is one. My instruction, no, that is the only.
We take instruction that is.
Naxalite activities are now under control.
No, you are not
Don't
in.
you
are not in.
Go outside and start.
You are the inmates. Now attacked, everybody escaped. Last time Lordship wanted to file affidavit.
The learned counsel, have you, the affidavit is ready with you?
This affidavit is there.
So why are you not filing? That IIC R. Udayagiri police station was asked to, how he made a false statement that that the petitioner is not involved in any case because one case was there and he was, that is pointed out by Mr. Jena himself, that one case was there, he faced trial and in that case he has been acquitted. So what is his affidavit?
Affidavit is, my lord, that is the
What he has stated?
Bail petition itself, I have disclosed that. It is there. Paragraph 4, my lord, that Deputy further will submit that. So for having the another case in relating to the R0 application of 2026 concern, the same is way back of the year 2006 and during the verification of the CCTV data, criminal entity prior to the year 2000 was not available as not uploaded. But when the criminal reference data of the accused person, including the present appellant, is available in CCTV after 2014, for such inadvertent mistake, the said criminal entity informed.
You say that the 2006 case, it was not reflecting in data. Data 2014 onwards, the data were available.
And the co-accused has been released. But who also asked for the conduct and from the jail because they are available.
It is jail conduct.
And this is jail conduct. Product, subject product.
Addition the case. Yeah.
reference. I am including this one, I have total 5 cases of mercy. So for 4 other cases, that is the petty offences. And all the cases I am bail and facing trial also, 1 case record is not found. The custody certificate and also earlier occasions you can.
There is a 5 antecedents there.
Including this one 5.
Now, এইটা হচ্ছে last 5 number mention ହେଇଛି. Other cases are also
Evidence sharing ଅଛି.
appearance में ଅଛି.
Evidence is.
But those are all magistrate tribal offences. This is only the case which is P02 case.
Because of the puja, Muslim puja, that 379 is there.
Oh, 379.
By to Lingaraj Mandir.
Bhubaneswar.
Period undergone?
Circumstantial evidences like.
No. How much you have undergone?
I am custody since 2010 years.
2008.
10.
10.
Yes. Around 15 plus years. And once I have already released an interim bail, there is no bounds.
As for another activities, ରହୁଛି ନା ସବୁ ଗୁଡାକ କେସ୍ ହଉଛି ଲିଙ୍ଗରାଜ.
Impose any stringent condition.
Stringent କଣ ପୂଜାରେ ସେ ଯୋଉ
ପୂଜା time
ମଣ୍ଡପ ସେଇଠି ତ ବୁଲିକିନି ହେଲେ ସକାଳୁ ସଞ୍ଜ ଯାଏ ବାହାରିଯିବ ଆଉ କଣ କେତେ ଜିନିଷ ଆସିବ ଚେନ୍ ଠୁ ଆରମ୍ଭ କରି ପର୍ସ କେତେ ଜିନିଷ ଆସିବ ଥାଉ ତ ଏଇଟା ଛୁଟକି ପଡୁଥାଉ ଆଉ ସିଆଡେ ରଖିଦବା ତାପରେ କଟକରେ ବାଲିଯାତ୍ରା ଫାଲିଯାତ୍ରା ସରୁ ସେ ଆସିବ.
Too long hours reopening ki tha.
But he has to collect the fee for the lawyers and so many things he has to do. So
let me reopening your notes.
पूजा vacation तो और ठीक है इस पैकेज ऑफ पूजा
Problem.
Number 41.
Last occasion called for the custody certificate as well as the conduct of the accused inside the jail. He is also confined to jail since 2014. I paid 2014. Near about 12 years in custody.
It's a double murder case. The eyewitness is there, 227 and 11.
Bail application was also rejected.
23.
Out of 54 hours next. On Anikele, either produce
My lord,
That
intellectual
custody
the Learning Council for the
conduct
state
to be.
has produced the custody certificate as well as conduct certificate which is taken on the first order after puja holidays.
you are doing very well in jail. You are doing very well in the jail. Continue.
Question number 42.
Mobile phone. On behalf of your government, you explain Honorable Court directed to obtain instruction regarding conduct of the petitioner and custody certificate.
How many times you have been granted interim bail?
Interim twice. Next, bail rejected once and then subsequently granted interim bail.
No, interim bail to ଯାଇଛନ୍ତି କେତେ ଥର ଯାଇଛନ୍ତି?
2 thar.
2 ଥର.
Surrender in time.
କିଛି ଗଡ଼ବଡ଼ କରିଛନ୍ତି ତା ଭିତରେ? ଏରା କେତେ ହିସାବ କରିଛନ୍ତି? 3483 ଦିନ.
9 ବର୍ଷ
5 মাস।
9 ବର୍ଷ 5 ମାସ। ଲୋକ କୋଉଠିକାର? ମୟୂରଭଞ୍ଜ। ମର୍ଡର କେସ୍ ନା? Single murder. Committed murder of the father. This father means निज बापा ना informator बापा? Bhimo Deuri अच्छा. On so son of Bhimo Deuri was sleeping in the so. In the night, his mother arrived and informed him that Navo Deuri committed murder of his father. Only he killed your own father.
You will do the eyewitness.
No, this is Duryodhan.
This is Bhimana.
Nephew.
Duryodhan লেখা আছে। নবদেউরি son of Duryodhan।
Good.
রিপোর্ট লেখা cross check।
তাহলে এটা কি? His father মানে এই তো বাপা মানে
ইনফরমেটর।
হ্যাঁ ইনফরমেটর বাপা। ইনফরমেটর বাপা মারছে।
এটা পুত্র nephew।
হ্যাঁ
nephew হবে।
They are related, huh?
Eyewitness কিয়ে করছিলেন?
PW2
PW2 ର harmful evidence. Oh, that is that widow of the deceased.
Widow. Bhima were sleeping in our house. The accused and the door asking us to open it. I opened the door. As soon as I opened the door, the accused started beating me up. I protested and so also Bhima. The accused then dragged the Bhima out of the house into the open field in front of the house and pressed his neck, suffocating him. I ran to the house of Petrovasi for help. When I came back to the spot with Petrovasi, I saw Bhima lying dead in front of the house.
So strangulation. Leg to মানে যে তন্টি চিপি কিনে and who is the doctor?
PW17.
This is PW17.
On examination of the external appearance, cranium and spinal canal, probes, abdomen, muscle and bone, I found the deceased as a healthy male with a face, sinusoid and swollen. The pupils were melted and there was a bleeding from both the nostril and mouth. Tongue was protruded of the lip, neck swollen, chest wall and swollen.
Injury was cause of death was due to traumatic asphyxia caused by fracture of briefcase. So
rib fracture लिखा है।
রেস করছি তারপরে বলে কোন কেমতি স্ট্রাগল করছি কোন করে দেবো আপনি ଯାଇছি ଯୋଉ କେତେଥର ଯାଇଛନ୍ତି? 2 ଥର। ଲାଷ୍ଟ ଟାଇମ୍ କେତେ ମାସ ଯାଇଥିଲେ?
Last time ଯାଇଛନ୍ତି 90 days. 90 days.
ଗୋଟେ ଥର 12 ମାସ ଯାଇଥିଲେ।
8/8/24 ରେ
12 months।
3/23 ରେ ରିଜେକ୍ଟ ହେଇଥିଲା। 18%।
10 years ହେଇନି।
नहीं 10 years होने 10 years सही नहीं
10 years ହେଇନି ନା ତ फिर ये होते जाए
9 years
9 years କେତେ ହଉଛି 5
5 ମାସ
है
9 ବର୍ଷ 5 ମାସ
so years let it be 10 years
ଯାଇଥିଲା କେବେ last time ଯୋଉ? ଅପ୍ରତିମ
8/8/24 ରେ interim ଦେଲେ।
नहीं लास्ट के भी
18/3/25.
18/25
One will be law of surrender, this is surrender. Okay. Land counsel for the state. Custody certificate. It is taken on record of this matter after ensuing puja holiday.
Item number 43.
Yes, my lordships, in this matter, I am through VC, my lords. As per the last order's direction, lordship, I have supplied the deposition copy to the learned senior state counsel. I have also filed my power of attorney V-Nama, my lords.
So your name is there, Mr. Manor, your name is there.
But last time it was stated that the Wakalatnama is not there. So I have filed it again, my lords.
A prisoner's petition received from jail for engagement of so and so. And Wakalatnama filed to Lekhaji there, let us see. Wakalatnama, yes, that is there.
Yes, lordship.
No problem.
My lords, in this matter, I have suffered 9 years, 3 months, and 15 days of custody. It's a case of no eyewitness, case based on circumstantial evidence, my lordship. And my antecedent and my jail conduct was for.
It is the wife. Cause of the death is, my lord, asphyxia, strangulation.
Occurrence, the dead body was found inside the house.
House, my lord.
No, my lordship. No, my lordship.
Yes.
Just see, lordship. PW 15 statement. PW 15 is a police officer at point number 12, just above.
After occurrence, they shifted the dead body to hospital.
She was not died inside the room. She was in the living state in the hospital. So that statement is.
Which one? The
lordship, PW 15. PW 15 is a police officer.
Yes.
And his deposition, lordships, at point 11. Last 3 lines. Dr. Patil has stated before me that the patient was in critical condition and was struggling for breath, for which she was referred to higher center and she was brought to the hospital for treatment. So the statement that she died inside my house is wrong on the face of it. My lords, further, if we see the merits of the case, just 4 points I will like to submit. First of all, lordship 313 CRPC. It is the settled rule of law that
who has taken her to hospital?
Yes,
me. Can I have a glance to the PW 10? The doctor.
Husband.
PW 10.
Well.
Which line?
My lord, PW 10, my lord. The injury number 2.
No. We are asking you a question that
who has taken
carried the deceased in one injured condition to the hospital where ultimately she died. Whether it was the
father of the deceased stated that PW 1.
Mr. Manor, where is that line that it was the accused who shifted her to the hospital?
Lordship, it's there is evidence of defense. DW1. DW1. And he has stated the entire story. And that the learned court below has just completely thrown away those evidences. It was me only, lordship, who just accompanied with my wife to the hospital.
With the father?
PW1, paragraph 4.
4.
My lord.
What's the statement?
On 4/5/2016 at about 8 a.m. in the morning, I got telephonic message from the father of the accused that deceased fell down in their house after she lost her consciousness and requested me to reach their house urgently. Myself, my wife, and 2 sons and daughter all came and reached 4 p.m. at Gunpur SD hospital. As we are informed that she was taken to Padampur hospital, from where
she was referred to Gunpur. By that time, Anita has already expired and was kept in the mortuary situated adjacent to postmortem room. I observed dark color mark on her front neck and cheek just
So
below the
that means prior to arrival of this man, he was already shifted.
Yes, sir.
So any neighbors were examined actually?
Yes, Lordship. DW1.
DW1
is the neighbor.
DW1. Say DW1.
DW1 is the neighbor, Lordship.
DW1 is all right. Any prosecution witness has stated about that? That because the doctor's evidence indicates it's a homicidal death.
No, Lordship, that is not the final opinion. May I read some lines from the doctor's statement? 10, PW 10. PW 10, Lordships. Lordship, at point 8, death due to asphyxia can also be possible in accidental death.
No,
by
those
high-
are the alternatives.
Yes, Lordship.
Since
So
that
the
it can be done in this way, that way.
And some injuries are also there on the body.
unless until the opinion is of fixed nature, conclusive nature, so that cannot be presumed. It's
So
murder.
how there was scratch mark also 6 to 7 in number. What is the period of detention? As you said,
Lordship, 9 year, 3 months and 15 days. The custody certificate may be seen. My antecedents.
Exhibit 7 is the exhibit. So exhibit লেখা আছে কি আনে গে exhibit 7 the doctor যখন লিখলে so লেখা আছে না কি আনে গে সেটা exhibit 7 কাম
exhibit 7 the postmortem report.
কি
That is accompanied by লেখা আছে report. DM বলতে এমন সমস্ত পয়েন্ট যাইছে অন্য মানে
কি হসপিটাল মানটা
hospital very evidence
আউটডোর পেশেন্ট হিসাবে
The statement of police officer is also, Lordship, may be seen kindly. P16.
The inquest was on the actually.
Did not think it's sure. In any case, that was taken place in our alone.
Cremation for a ଶାଶୁ ଶ୍ୱଶୁର so and so ଆମ ଘରକୁ ଆସି ମୋ ଝିଅକୁ ନେଇଗଲେ 30 ଲକ୍ଷ ଟଙ୍କା ମାଗିଲେ ନହେଲେ କେସ୍ କରିବେ ବୋଲି କହିଲେ ବାପା ମୋ ଝିଅ ବାପୁ so and so ମନା କଲାରୁ ମିଛ ବେଟିକି okay
Lordship, custody certificate may be seen. Point 7. May I read, Lordship? Custody certificate at point 7. He bears good moral character, well behaved and sober by nature during his confinement.
all right miss case number no this is IA number
Lordship, I number 443. 443 of the 19.
What is that 443? 443 of 2019.
19 for bail.
This is an application for bail. You have been granted interim bail.
Yes.
Yes, Lordship, earlier, but
25/9/2020
submits that the petitioner is in judicial custody for more than 9 years, which would be evident from the custody certificate of the senior superintendent circle jail Koraput, dated 4/8/2025, wherein it is also mentioned that the petitioner's conduct in jail was good. The Land Council submits that the petitioner was granted interim bail as per order dated 25/9/2020, 25/9/2020 for a period of 21 days. And he surrendered at the right time after availing the interim bail period. He further submits that the case is based on circumstantial evidence and there are good chances of success in the case and balance of convenience is in favor of the petitioner. And since there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and argued that the petitioner is the husband of the deceased, and when the deceased was shifted to the hospital, the family members arrived there and they found injury around the neck of the deceased, and PW1, the father of the deceased, has deposed to in that respect.
PW7 also.
Also PW7. He further submits that the doctor PW10 who conducted post-mortem examination also found injuries like abrasions and scorch mark on neck of the body of the deceased, neck and chin of the deceased, and opined that the cause of death was due to
asphyxia.
Asphyxia. It is argued that the petitioner was staying in the company of the deceased at the time of occurrence, and no explanation has been offered by him in the statement recorded under section 313 CRPC as to how the deceased sustained such injuries. Considering the submission made by the Land Council for the respective parties in view of the nature of evidence available on record and the post-mortem report finding, while not inclining to release the petitioner on bail on merit but taking into account his period of detention in judicial custody for more than 9 years and absence of any chance of early hearing of the appeal in the near future, we are inclined to release him on interim bail for a period of 3 months. Put of this matter on sworn, so surrender certificate is to be filed. The name of Mr. Tupuna Kumar Mishra shall not be reflected in the cause list henceforth. Yes.
I'm obliged, Lordships.
Item 44.
May I please, your lordship? My lord, last occasion, order number 10, IA number 13/24, interim bail 3 months. Now, IA number 667/23, order number 6, bail order 70 days by 2 times interim bail. Out there, Khar Jaitila, my lord. Tinta I have hiding, my lord.
The last order it was passed, Mr. Tripathi.
Yes, madam.
That you are to produce the surrender certificate.
Yes, madam.
So, where is that? Last time you were granted interim bail And
Yes.
the last order was passed also that you are to produce the surrender certificate. So have you annexed that surrender certificate with your bail application, which you have filed now?
My lord, report is there, back case.
Back K.
My lord.
Order number 6 manual 25-25 रे surrender होई manual court रे due time रे manual surrender होई
Condition that's one so.
order number
the
6
accused Manu has
25-25
surrendered court to the charge. ठीक है. All right. That's a report is there. So anything adverse against him during the interim bail period? Because he has gone on interim bail twice.
My lord.
One first time on 5/3
Last occasion only.
24. That
We have
was a
received the
period for
custody
10
certificate.
years.
Custody certificate we have received 9 year 11 month custody, but conduct not received. In this case, eyewitness also there.
minor 10 years 7 months
हाँ कितने वर्ष?
already 12-15 10 years 7 minor 3 days
10 years.
10 years 7 months.
minor 12-15 custody 5 months 10 days interim ଆଉ 1 month 7 10 years
2025 पर्यंत ଦେଇଛନ୍ତି 25/3/2025 9 years 11 month ये
10 years above.
हाँ सही है
10 years 7 months 3 days minor 5 months 10 days interim minor
no criminal incident.
Part the Land and Council for the petitioner Land Council versus State. Mr. Tripathi Land Council submits that the petitioner is in judicial custody for more than 10 years. And this court has granted interim bail to the petitioner twice. First on 5 wide order dated 5/3/2024 for a period of 10 weeks, and again wide order dated 11/3/2025. No, sorry, 25/3/2025 for a period of 3 months. And on each occasion, after availing the interim bail period, he surrendered at right times. And since there is no chance of early hearing of the petitioner, early hearing of the appeal in the near future, the bail application may be favorably considered. Land Council for the state has often impression that nothing adverse was reported against the petitioner while on interim bail. Considering the submission period of detention of the petitioner in judicial custody, fact that he has not flouted the terms and condition of the interim bail granted twice, and absence of chance of early hearing, we are inclined to release the petitioner on bail allowed.
obliged.
Yes.
Item number 45.
Please, Your Lord. Well, sir, can you have a plans for order because 22/8/2024? 22/8/2024. Wherein your lordship was pleased to extensively hear the matter and was pleased to grant me 3 months of interim bail.
Okay, then you surrender.
My lord, I have surrendered and I have renewed my prayer for bail.
What about the conduct? Anything adverse? No. How many years you are in custody?
I am in custody since 2015, 8/10/2015. Almost.
8-10, actually. Except that 10 months period, sorry, 3 months
3 months
period,
period.
you are in custody always.
Okay.
So it must be more than 9 years then.
9 months.
9 years or above it. Part the Land and Council for the petitioner Land Council. The Land and Council for the petitioner submits that the petitioner is in judicial custody for more than 9 years, and he was granted interim bail for a period of 3 months as per order dated 22/8/2024. And after availing the same, he surrendered at right time. and he has not misutilized his liberty in any manner. Therefore, the bail application, and therefore, and since there is no chance of early hearings of the criminal appeal in the near future, the bail application may be favorably considered. Learned counsel for the state has produced the report dated 15/9/2025 from the IIC Sointala Police Station, District Balangir, to show that the petitioner, nothing adverse was reported against the petitioner during the interim bail period. The report is taken on record. Considering the submission made by the learned counsel for the respective parties, period of detention of the petitioner in judicial custody, since the petitioner has not flouted any terms and conditions of the interim bail order, and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Grateful.
Data 46.
Whether your bail application was earlier rejected?
No, Malisi, that is the earlier.
How many years you are in custody?
It's that Malisi, 7 years and that.
7 years, 8 months.
What is the weapon of offense with which you assaulted the deceased? Axe.
Accidents.
Eyewitnesses is there.
The eyewitness not to the occurrence, but the eyewitness who see me after reading the house played her.
You are being away from the spot.
Yes, ma'am.
Holding that axe.
Yes, ma'am.
Who is the eyewitness?
The female one is the.
One has seen killed out. And you also gave recovery of that weapon of offense.
Yes, ma'am.
It was found bloodstain also.
Bloodstain, blood matching, group is matching. The blood.
Why you, what is the allegation? Why you killed the deceased?
That malice is the civil dispute.
Civil dispute.
Yes, ma'am.
Nephew, deceased and uncle and nephew.
How many blows have been given? One or more?
That malice is as per the
PM report.
PM report.
27. Doctor is 27.
27. Discussion is not part of it.
Temporal bone right side 5 to 6 cm depth.
Single.
Breath also 5 to 6 cm.
Good blow these.
Blow and severe 5 to 6.
Depth বেশি পড়ছে সসিএম ভিতর পশ্চিম মানে কম না
শৈব অবস্থার মানে
Total custody period?
7 years and 8 months.
7 years.
7 years and 8 months.
After vacation, custody certificate produced after vacation. Yes, next.
Item number 47.
Your Lordships, on the behalf of A.R. Panda, I am
The next list means tomorrow it may also come. Okay.
Item number 48.
Yes, Mr. Mahapatra.
Madam, earlier the bail petition was rejected on 14/12/20. That is IR number 1244 of 20.
In the year 2020, your bail application was rejected.
Yes, madam. And thereafter another petition was filed that was withdrawn,
Okay.
not pressed.
How many years this man is in custody?
Custody,
Your state council was asked to produce the custody certificate and also obtain instruction about the criminal antecedent jail conduct. कौन हला?
Criminal antecedents, 14 criminal antecedents.
14 criminal. Give. Have you obtained the other things, the custody certificate? The Learning Council for the, have you got this list of cases?
Comprehensive affidavit
नहीं अपन उटे copy दे देले सुविधा. You give him copy to the Mr. Mahapatra also.
make a xerox on it.
हाँ, xerox करके दे दें. Land Council for the state has produced the custody certificate. दो चंदो. Custody certificate which is taken on record. He has also produced the written instruction received from IAC Kujan police station to show that there are 14 criminal antecedents against the petitioner. The copy of the written instruction is handed over. I'm Lekhiduji is handed over. That's the Land Council for the petitioner who wants to obtain instruction on the same and file a comprehensive affidavit relating to the status of those cases. Hello? That are Xerox going to. See that Yar sufficient manager. And it is to come after Puja holidays. Yes.
ये custody certificate of conduct certificate है.
State of custody certificate of the
Custody certificate of conduct certificate conduct है.
Yes, next.
Item number 49.
May please. Here there are two appellants, madam. Out of them, appellant number 2 was already released on bail by this honorable court. And so far as this petition is concerned, is appellant number 1. His bail application rejected twice.
Purnachandra Das.
Yes. It was initially rejected on 15/12/2022 and thereafter in August 24, madam. Again, the second order rejected my bail application. I approached the Honorable Supreme Court. The order of the Honorable Supreme Court is at page 7, madam, of this application. There, the Honorable Supreme Court granted me liberty to file an application for bail before the Lord in this Honorable Court after about 6 to 8 months. And this order was passed on 18/11/24. So after about 8 months, I filed this application. And the petition's custody for about.
No, this order was passed on 18/11/2024.
Yes, ma'am.
When you bring this to the notice of this court, that the Honorable Supreme Court has directed for expeditious hearing, and in case it would not be held, then you did not bring it to the notice of this court that such a direction was passed. Now you just skip over that period of 6 to 8 months, then you have filed this interim application. We could have taken up this matter for hearing in view of the decision of the order of the Honorable Supreme Court.
Yes,
But the period undergone?
About 8 years. 1 month short from the 8 years.
Custody certificate.
Paper book is ready.
Ready.
This is 2021 appeal. Why should you get merely because you could afford to go to Supreme Court? There are many people waiting. I know, merely because you afford to go.
Submission could
Oh, that's right.
We request the High Court.
But merely because you can afford to go to court in their preference. The people who are not able to go. That's the identity.
You get ready for hearing. We are keeping this matter to after the holiday. The interim application for bail. Mr. Dhor and counsel appearing for the petitioner submits that after the bail application of the petitioner was rejected by this court on 30/8/2024 by IN number 1864 of 2023, the petitioner approached the Honorable Supreme Court and by order dated 18/11/2024. So the special petition was dismissed, but this court was requested to take off the appeal for hearing expeditiously, and in case the appeal not be taken up for hearing within 6 to 8 months, it would be open to the petitioner to file a fresh application for suspension of sentence.
Bail application is filed on 28/8
This bail application was filed on 28/2025. Obviously, after the period was a period as fixed by the Honorable Supreme Court has elapsed. However, the petitioner has not brought to the notice of this court about passing such an order of this court, even though the paper book is already prepared in this case. In view of such put up this matter after ensuing puja holidays. है ना? The council may get ready for hearing. Yes, next.
Item number 50.
Lordship, again, I am seeking pass over on the behalf of Mr. A.R. Panda. So Lordship, kindly pass the similar order.
Yes, next.
Item 51.
To the committee for
petitioner file. That has not issue.
Get it. Mr. IN number so and so, this is an application for bail. Mr. Tripathi, Learned Counsel, submits that the petitioner was granted interim bail for a period of 3 months as per order dated 21/2025, and after availing the same, he surrendered at right time. Mr. Tripathi, he surrendered at right time.
Yes, my lord.
All right. The Learned Counsel
not failed. Surrender certificate not failed.
Where is the surrender certificate, by the way? Why is it not filed? The
File, surrender only file
Acha.
portal, my lord.
The Learned
Document
Counsel,
number?
however, not filed the surrender certificate. The Learned Counsel for the state submit that he will obtain instruction as to whether the petitioner has surrendered at right time or not, and also about his conduct while on interim bail. Put up this matter after ensuing puja holidays.
Item number 54.
Yes, please, Lordship. I am appearing on behalf of Ashok Kumar Behra, madam.
Yes.
So, matter may be next week.
Deposition copy they have not served.
The Learned Counsel for the petitioner, appellant supplied the deposition copies of the witnesses to the Learned Counsel for the state in court today, who seeks some time to go through the same. Learned Counsel for the appellant also seeks for an adjournment after puja holidays.
Item 56.
You are also managed offense under section 302 of the IPC managed.
What is the period of detention?
Detention is in custody since 21/8/2015.
15.
No.
Your bail application was never rejected earlier? This 4.
Married, subject to correction, married, I think it has been deferred only.
Just a minute.
That is subject to correction, married. Because as far mine, it says, I have some. I will make it.
No, it has not been. By the way, where is your custody certificate? Have you taken the averment since when you are in custody?
That has not been stated in the bail application.
The Learned Counsel.
Custody certificate not there.
Get it, and also
Yes.
criminal antecedent.
Yes.
First time it is Mr. Mishra and senior advocate appearing for the petitioner submits that the petitioner is in judicial custody since 21/8/2015 and was taken into judicial custody since one so date such and such date. And he has never been released on bail during trial. Not released. The Learned Counsel for the state seeks some time to produce the custody certificate as well as criminal antecedent, as well as to obtain instruction relating to criminal antecedent, if any, against the petitioner. So also his jail sentence. Put up this matter after ensuing puja holiday. Yes.
Obliged.
Item number 57.
In 57 first matter, we are appearing also.
Okay.
My lord, in custody since 12/8 to incident is 12/8/13. My lord, date of arrest is 16/8.
Your bail application was earlier rejected or not?
It was rejected earlier on 19/12/2022. 2035.
Just.
My lord, I am appearing on behalf of the informant.
Yes.
Incident
What
of
do you
last-
say?
My lord,
any any criminal antecedent against the petition?
No. I am for the information.
I'm asking you that whether you are supposed to know about the criminal antecedent.
Yes,
if any.
criminal.
How many cases are there?
That I am not knowing
Then
criminal
how can
antecedent
you
are
say?
there. There is clean and cogent evidence is there.
We are asking you something, you are answering something else. We are asking you whether there is any criminal
That I will
antecedent.
verify.
Against solid law,
Huh?
solid.
Salil, the second one.
Second
Mr.
one.
Sarangi is moving the Suraj Sharma case.
I am for the second survey.
Huh?
So Das is for the
Second survey. Second survey.
No, we are going to the, we are taking up the first matter.
Suraj Sharma. What is
Suraj
the
Sharma.
criminal antecedent?
First is mine.
Your paperwork has already been.
One criminal antecedent.
Paperwork has already been ready for it.
So why will take up 2022 matters? We are considering the bail application. It is being listed for orders. And you are telling that paper book is ready. Many cases paper book have been prepared. So we will take up all those matters for hearing. Will not consider the bail application.
In the first matter, my lord,
Yes.
the present appellant has one criminal antecedent. In this case, the accused person demanded body
Yes.
to the deceased. When the deceased denied, they fired. Eyewitness are there, my lord. Yes.
Already put up after vacation.
I am not named
May I
in the FIR also. Lord.
We'll see that after vacation. Yes, that-
May I-
Yes, next.
Allows me a minute.
Item number
After
58.
Puja. Yes, next.
Number 58. In the first matter, that is criminal of one. And I am appealing for appellant number 4. In which my order dated 1/9/2025, my lord had directed me to file supply copy of the interim bail application.
Yes, my lord. The petitioner filed an interim bail. Here, 4 appellants are there. For whom he has filed interim bail, that
Name
is
is
not
written.
mentioned.
No, name is written. In
Kindly
the
have a
or- said order, the name is written.
Order, जो interim application ମୁଁ ପଠେଇବି instruction ନବା ପାଇଁ ସେଥିରେ ତ କାହା ପାଇଁ interim application file କରିଛନ୍ତି that is not mentioned.
Coran alias Jabir Box IRA first 9 ଲେଖା ହେଇଛି. My land plan.
Your IN number is Mr. Bose.
Yes, ma'am.
IN number कितने?
1137 of 2025.
1137 पर लिखा है गोरा alias Jabir Box गोटे ना लिखा है though the appeal has been filed by
4 appellants, my
4
lord.
appellants, but he
हाँ, तो लिखा है कि-
ना तो लिखा है जो कौन?
And my
Sir,
lord
I have
also
not-
reflected that in the order itself.
हाँ तो कौन है इंस्ट्रक्शन नहीं चल
नहीं instruction से चिट्ठी करना थे last time
ସେଇଟା
Mr.
ନେଇ ନାହାନ୍ତି ଆଉ ଇଆଡେ ସିଆଡେ ବୁଲଉଛନ୍ତି କଣ ନିଅନ୍ତୁ ଇନଷ୍ଟ୍ରକ୍ସନ
ନାଇଁ ନାଇଁ
Appellant number 4.
ଆପେଲାଣ୍ଟ ନମ୍ବର 4 ପାଇଁ ଲେଖା ହେଇଛି ଅର୍ଡର ବି ଇଜ ରାଇଟ ଅର୍ଡରରେ ବି କ୍ଲିୟର ଲେଖା ହେଇଛି ଯେ ଆପେଲାଣ୍ଟ ନମ୍ବର 4 ର ଏଇଟା ଆପ୍ଲିକେସନ ବୋଲି
ସେ ଡ୍ରାଫ୍ଟ କରିଦେଇଛନ୍ତି କିନ୍ତୁ ପଠେଇ ପାରୁନାହାନ୍ତି କାହାର କନଫ୍ୟୁଜ ହେଇଯାଇଛନ୍ତି
ନାଇଁ,
ଉପରେ ଦେଖୁନାହାନ୍ତି
Yes.
ଲେଖାଉଛି oral
ବୁଝିଲ ସନ୍ଧ୍ୟାବେଳେ ଅର୍ଡର ଗୁଡାକ ଅପଲୋଡ ହଉଛି ସବୁ କେସ ର
application ରେ ଦେଖ
ଆପ୍ଲିକେସନରେ ବି କ୍ଲିୟର ଅଛି ଲେଖନ୍ତୁ the land and council for the state seeks some more times to obtain instruction on the interim application filed by appellant number 4 CORAM alias Sheikh Jabir Bucks on the ground of mother settlement. And of mother settlement rachi next week rasu
मैंने
बुधवार दिन
Page number 518 in the same appeal. The same appeal.
गोटे गोटे व्यस्त कहीं बुझे ना
No, ସେଇ appeal ରେ
हाँ ये अपील कौन है
ଆଉ ଗୋଟେ IE ଅଛି 518.
ସେ ତ ଏକାଥରେ ନିଆବ ଆଉ
ନା ତାର ବି ମଗେଇ ଆଣି ନାହାନ୍ତି ସେ କହୁଛନ୍ତି ଆମେ ତାର ବି ଡାଇରେକ୍ସନ ହେଇଥିଲେ ଆଣିବା ପାଇଁ.
କୋଉଟା ସେଟା ନମ୍ବର କେତେ
आइए नंबर
ଏକ କ୍ରିମିନାଲ appeal 1 of 2023.
ना ना आइए नंबर
IE number 518.
518 तो कॉपी नहीं
518 ଟା का ପାଇଁ ଫାଇଲ କରିଛନ୍ତି
Only for appellant number 3, my lord.
appellant number 3
ଗୋଟେ କପି ଟେ ମତେ ଦେଇଦିଅ
copy not sir my lord. My lord directly
just
Copy.
informant ପାଇଁ ଅଛନ୍ତି ତ ଲେଖନ୍ତୁ IN number 518
South com.
yes yes
518 of 2025 this is an application for bail for appellant number 3 କଣ Sarfu alias Sheikh Sarfuddin
Sarfuddin.
let a copy of the interim application be served on the land and council for the appellant during course of the day
मत दे
Right.
and you have received the copy
No my lord.
ତାକୁ ବି ଦେଇଦେବି.
so also on the land and council for the informant the land council for the state shall obtain instruction on the interim application, matter to be listed on 24th.
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଲାଷ୍ଟ ଡେଟ୍ କହିଥିଲେ ସମସ୍ତଙ୍କର ଆଣିବା ପାଇଁ
Custody certificate.
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ
Achi ka niyashan.
Of all. Yes, yes.
Niyashan.
Custody certificate.
This is to be listed along,
Criminal accident भी ଆସିଛି.
this is to be listed along with the criminal appeals. ये जो कौन 1168 ଅନ୍ୟାନ୍ୟ ଜିନିଷ ଅଛି 24 ତାରିଖ ଦିନ ଆସିବ. Yes,
24th minutes.
24 ତାରିଖ.
Item number 59.
Mr. Konda.
Custody since 2009. I have been in custody since 2009. 14/7/2009 and languishing.
Jaina the bail jama.
I have been granted interim bail for 2 weeks on the last occasion by order dated 12/3/2025 on the ground of the death of my father.
No, no, how,
No, my lords, the appeal was filed only in the year 2023.
but,
Superkiller, my lord, number of criminal antecedent.
so give those so that you will file a comprehensive affidavit.
Yes.
And what about this custody? Is saying that about 15 years is in judicial.
Different jail case.
No, no, ei case re kotha kon. Ei case re kebe remand re niya gala ba custody re ani kini अन्य case re
I
remand.
have obtained custody certificate.
You obtain that custody certificate.
It is already off.
No, custody certificate.
On the
Criminal
last
accident.
occasion, your lordship was directed for custody certificate as well as antecedent. And the
Achi ki hai na.
Criminal antecedent.
Direction
was
given earlier, my lords, for all. IN number 1798 of 2024. Order ta bhar karo last order ta. The Land Council for the state submits that he has only received
The criminal
instruction about the criminal antecedent, but he may be given some more time to produce the custody certificate. He has filed the criminal antecedent report, which indicates that
Bikram Kesari Malik has 8 criminal antecedent.
Petitioner has got
8 criminal antecedent and it's a number 2.
Petitioner has got 8 criminal antecedent.
Another submission, my lord, the IAC told me that in other districts he has also criminal antecedent.
Have you received the copy of this one? Let a copy of the criminal antecedent report be supplied to the Land Council for the petitioner in order to enable him to obtain instructions, the status of those cases and file a comprehensive affidavit. Put up this matter after puja holiday.
That's my only small query is I was granted interim bail. Let the conduct be also.
That is also there.
Again.
The Land Council for the states shall also obtain the instruction relating to the conduct of the petitioner. No, inside jail lekha hai ji?
No, he was granted 2 weeks of interim bail by order dated 12/3/20.
Inside the jail as well as his conduct during the interim bail period of 2 weeks, which was granted as per the
Order dated 12/3/2025.
12/3/2020.
And so in the sub item also, the appellant is in custody since long.
Both the case.
Both the cases are.
Both the case
ତା ଦେହରେ ଅଛି ପରା ସେ ଯୋଉଟା ଅଛି ତା ଦେହରେ 2 ଜଣଙ୍କର କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ଅଛି ଏଥିରେ ଯୋଉ 8ଟା ଲେଖା ତା ତଳେ ଦେଖିବେ ଏ ଯୋଉ ଆର ଆପେଲାଣ୍ଟ ର ଅଛି ହେଲା ତାର ନମ୍ବର ଅଫ ଏଇଟା ବୋଧେ କମ ଅଛି କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ କିନ୍ତୁ ଅର୍ଡର ସମାନ ହବ ହେଲା
ସେ କେବଳ ଗଞ୍ଜାମ ଜିଲ୍ଲାରେ ଦେଇଛନ୍ତି ଅନ୍ୟ ଜିଲ୍ଲାର ଓରକେଲେ ଜଜମେଣ୍ଟ
obtain that. Yes, next.
Dateful minutes.
Item 60.
Extension of Indian bail, that was in intentional surrender certificate.
IN number 2347 of 2025. This is an application for extension of interim bail. Mr. Raut Land Council for the appellant submits that since the appellant has already surrendered in the meantime before the Land Trial Court, this interim application has become infructuous. Accordingly, IA is disposed of as infructuous.
That one.
आप फाइल कर जल्दी
I call regular bail for 1318.
नहीं आसी नहीं record नहीं केबे फाइल करछन
This order was
1318
asine. 7/7/2025 that order was directed.
Custody certificate.
Always custody certificate given.
Custody certificate is accused person are there.
Only
1318 is pending, yes, right?
Class D.
And
No order was passed in 1318, but order was passed. Order was passed on the that the state council shall obtain. Custody certificate you produce it should mention.
Only instruction regarding the
Conduct of the petition.
Conduct.
Anichandi.
Vikram Kesari Malik, he transferred to
Vikram Kesari Malik. এটা পরা বিকি আলিয়াস প্রশান্ত কুমার সাহু না না এটা হচ্ছে বিকি আলিয়াস প্রশান্ত কুমার রাইট ଟିକେ ରୁହନ୍ତୁ
ये custody certificate आपने
custody certificate ପୁରା ଅଛି
ना
we want that it has been mentioned that he was granted interim bail for some time in different interim bail applications. So we want that you should produce the report on the conduct of the petition.
that has not come. That has
Otherwise, custody certificate he himself has also produced.
that has not come. I will
Get it that the Learning Council for the State 6 এটা লিখিবে IN number 1318 কারণ এটা cause list আসেনি but this is pending 1318 of 2025 है ना? The Land Council submits that as per the order dated 7/7/2025 is yet to receive the conduct as instruction regarding his yet to obtain the instruction regarding conduct for the petitioner while on interim bail. Put up this matter after Puja holidays for you. That's all.
ଏଇ ଯୋଉ ଆସିଥିଲା ତମର ଯୋଉ ମରି ନଥିଲେ ସେଇ ରିପୋର୍ଟ ନା କେବଳ ଏତିକି ଲାଷ୍ଟ 6/8/25
Mr. Nayak, the item number 30 re we granted bail in CRL number 286 CRL varkala 286 of 2018 for a period of 3 months. So whether there is any bail application, I know it achi to dispose
286
then puch raha mujhe order dekho order dekho
30 शुभल
नहीं नहीं अच्छी अच्छी IN number 1256 of 2020. Who order and it's not procedure. Just a minute, let us see that.
IN number अच्छा तो वो कहानी अच्छी बसना एग्जाम बनती जो
order sheet ଦେଖନ୍ତୁ 25/9/2024 ରେ ଯୋଉ ଆମର ଅଫିସ ନୋଟ ଦେଖନ୍ତୁ ଆଦିରେ ଦିଟା interim bail application number ଲେଖା ଅଛି ଗୋଟେ ହଉଛି 1256 of 2020 ଆଉ ଗୋଟେ ହଉଛି IN number 448 of 2024. So whether both these applications have been disposed of. अच्छा कहीं से था अच्छा देखिए the council ki who has moved this application? Ask him that এটা বেল অ্যাপ্লিকেশন নাহি, ନାଇଁ ତ
Monday ଲଗେଇ ଦିଅ।
ମଣ୍ଡେ ଇଏ ରଖିଦିଅନ୍ତୁ। ଏଇଟା ତ ଏଇ ଯୋଉ ସେମିତି ଅଛି ଆର୍ଜନ